Please call the list. Item number 1.
I am for the led by Mr. Shukra Chattopadhyay.
This petition has become infructuous. To my lord.
Why?
Because আপনার দুই আমার
নাম বলো আমাদের পিয়ালি চল
পিয়ালি চল
চল
আপনি চলে যান
Yes.
it has become infructuous
Why?
because my lord she passed order for consideration of transfer. She obtained transfer. She was given the third school. First two schools being vacant, she made a representation with the commission that when first two schools are still vacant, why you are giving to me third school? Now eventually she has accepted the recommendation, accepted it. So it becomes this report.
I called for a report.
And this is the letter of appointment, my lord. Kindly see transfer order. This is the letter. Yes.
ও এটা করেছে মানে নিশ্চয়ই
She has accepted it.
Yes.
This is the my lord letter of transfer.
Learned advocate representing the petitioner submits. Grievance of the petitioner stands redressed. Stop. It is also submitted that petitioner has been transferred as per her preferred school, and such transfer order is accepted by the petitioner. Stop. In terms of in terms of previous order dated 8 April 2025 on behalf 2025 on behalf of District Inspector of Schools AC Purbo Bardhaman, a report is filed today in the form of affidavit and same is taken on record. Stop. Next paragraph.
Great.
In view of submission made on behalf of the petitioner, no further order need be passed on this writ petition. Stop. Writ petition stands disposed of. Urgent Xerox certificate.
Grateful. Well, be kept on record, man. This order be kept on record.
Not required. I have already.
Because I have no instruction, because no written instructions. This is I am relying upon. Because she has accepted it.
একটা ওখানে যে সাবমিশনটা বলছিলাম না, the transfer order dated 25th April 2025 is placed before this court and same is
grateful, my lord.
Taken on record.
Obliged, much obliged.
গ্রেট
Next.
Item number 2.
Plan for the state.
Hello.
Correction.
Stapler.
Issue. Matter has come up in the list matter has come up in the list for correction of the order dated 16 July 2025. So, in the cost title of the order dated 16 July 2025, name of the petitioner shall be read as Rezaul Karim in place of Rezaul Alam, quote unquote, quote unquote. So, next paragraph, department is directed to incorporate necessary correction. So, this order forms part of the order dated 16 July 2025. Next.
Petitioner, my client wants to withdraw this matter because grievance has been redressed. It is regarding extension of the recommendation period beyond 150 days. He has been given that.
Extension.
Affidavit of service be kept. Well, can you see the instruction of the client?
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Client advocate for the petitioner submits. Grievance of the petitioner stands redressed. And grievance of the petitioner stands redressed. Stop. In support of submission made on behalf of the petitioner, letter dated 1st August 2025, which the client advocate has received from the petitioner. It's a copy, it's not original.
It came in my WhatsApp, my lord.
You keep it with you. Unless until it is original, I will not take it. কি বলছিলাম? ওই last line টা বাদ দাও. The West Bengal Central School Service Commission and state respondents
Yes, ma'am.
are represented by learned advocates. Next paragraph. In view of submission made on behalf of the petitioner, no further order need be passed on this writ petition. Stop. Writ petition stands disposed of.
On instruction. So, petition on instruction.
উপরে কি বলছে আমি দেখো তো on instruction করুন। Next. আর affidavit service filed on with the petitioner টা করুন। Next.
Item number 4.
I am for this statement.
Report. It has been made ready.
Only one thing, Lord, yesterday, my lords, I submitted before Lordship in the pension papers, in signing his signature minute, all these things has been made an endorsement to the effect that without prejudice
So what?
in all stages, all
So
stages.
what?
My
Let
lord,
it be processed by the authorities.
Lordship makes such an observation. Otherwise, in the future, if any
No, I will direct that since the in which paragraph you have stated
Without objection,
in the report.
that has signed everything.
Yes. You have taken steps in terms of the this order.
Lordship will kindly take paragraph 8
Paragraph 8.
paragraph 8 of my report and also read it with page 11 of the report.
and another thing, my lord,
Just a minute.
Will also
Page 11.
and another thing, my lord,
Sir, this is a resolution of the
Meeting
body
dated
meeting.
25th July 2025.
Yes. And he was also present. It has been endorsed that all documents have been signed and he has also accepted. There is one contention. I would kindly, there's a one request, humble request. He is due to retire on 30th August 2025. 31st August 2025. Now the managing committee has requested him to come on 11th August where the new teacher in charge will be nominated and he should hand over the charge to the new teacher in charge
When?
on Monday, 11th August. So she kindly pass an order so that he cooperates with the handing over of the
This is not your writ petition.
if he does not hands over charge properly.
But why on 11th August? It should be on 31st August.
No, 31st August is his last day.
Yes.
So before that, he should start the process of handing over the charge. All the documents should be handed over. The new teacher in charge should understand everything from the headmaster. So this will take around 5 to 6 days or a week.
Then start it from 25th August. 7 days before.
Yes. No,
Start
what I
the
was
process of
saying-
process. Charge handing over process is nothing. They are the papers
No.
on a particular papers that what are the things which are being handed over and what are the documents which are being made over by the outgoing headmaster to the in favor of teacher in charge. These are to be narrated, nothing else.
Why I was saying, because if it starts on 11th, it might complete within the next 2-3 days. I would kindly request your lordship to keep the matter before, prior to 31st August on any day, so that everything is done.
Charge has
And
to be
your
handed over.
lordship can finally dispose of the
Handed over.
petition on
Only
that
one
day.
thing, Lord. My lord has recorded that they have signed on the pension first. So the PF Provident Fund is.
No, this is also stated that I put my signature at the relevant places where president's signature was required, which includes service book, provident fund papers, and
No,
other
that
papers.
is not signed. That is my, I am showing him.
Lordship, page
I am
11.
showing him. I am
Page 11.
kindly please seize.
Lordship,
Please seize.
11.
I am showing to
Page,
my
page
lord
11,
that
this is the resolution of the governing body.
my
There
lord,
will be, his signature is there. And lordship kindly takes column 2.
Lord, this is the paper.
To
I am handing over to my lord.
মহাশয় অবসরকালীন ফাইনাল পিএফ পেপারের জন্য যাবতীয় পেপার এই তারিখ সহ বিদ্যালয় পরিচালনা সমিতির সভাপতি মহাশয় স্বাক্ষর করুন।
The lordship, this is the paper. I am showing him.
Then why did he sign on the resolution?
No. That is not the question. This is the paper to be forwarded to the ADI for disbursements of provident fund. This particular thing has not signed.
Not need, there's a no litigation certificate.
Yes, that is to be given. Otherwise, I will not get it. Why this coming in the way?
First hand over charge.
Handing over charge has nothing to got with the release of pension papers. It's completely different issue. Why is putting a condition? Your lordship sees he's taking a resolution, get it signed, and now I am showing it.
This is a resolution drafted by you.
I am showing it
But
to
they are in
you.
the
Kindly
meeting.
seize it and take an instruction whether he has signed or not. Otherwise, I will not get it. I have to get it. If I get it, you have to sign it. Where is the litigation? Lordship, kindly seize it.
In terms of the order,
My lord, kindly seize this.
dated
Why
16
he has
July
not signed it?
2025.
And he
A
signed the
report
resolution.
is filed by the respondent number 7 in the form of affidavit affirmed on 31st July 2025, and same is taken on the court system. It has been disclosed in the report in paragraph 8 that a meeting was convened on 25th July 2025 in presence of the president of the managing committee of the school, being respondent number 7, and the petitioner being headmistress of the school.
Headmaster.
Petitioner being headmaster of the school. Stop. It has been it is averred in paragraph 8 of the report that respondent number 7 put his signature during the meeting at all the relevant places where the president's signature was required, which included the service book, provident fund papers and other papers relating to pension, which are to be submitted online. Stop. Resolution of the said meeting dated 25th July 2025 is annexed at pages 11 and 12 of this report, wherefrom also which supports or which corroborates the statements made in paragraph 8 of the report. Stop. Since respondent number 7 has put signature, court directs the school authority to forward the pension papers, including service book of the petitioner, to the concerned state respondents for processing pension case of the petitioner. Stop. Next paragraph. Court also directs the petitioner to hand over charge in favor of the teacher in charge, in favor of the teacher who is to be appointed as teacher in charge before his retirement, which is scheduled on 31st August 2025. And this court expects that petitioner shall cooperate with the school authority in the process of handing over of charge. Stop. Next paragraph. With the aforesaid direction, the writ petition stands dismissed. Next matter.
Grateful.
Next matter. I have directed to process your pension case. Yes. Your matter will not be kept pending. Sorry, Mr. Rai. Yes. Yes. I have stated in my order. You have not heard it. Yes. There is a specific statement in paragraph 11 that I have stated. Please call the next matter.
Item number 5.
Yes. Yes. Serve a copy upon him. Where is?
I am not in this matter, Lordship. I am in the next matter, item
It
number
has
5.
to be. Why you have not said so? You have said yes, because you have not pointed it out. That report has to be submitted to you.
This is the thing, Lord, he has not given, he has handed over to the court, I have not given any copy.
Acha, একটা কাজ করো। That has not been served upon you.
No.
Why you have not submitted it?
Lord,
You are saying so many things.
And I am saying.
Learned advocate for the petitioner, the learned advocate for the school authority is directed to serve copy of the report filed today by 7 days from date. Next. Copy of the report filed today by 7 days from date upon the learned advocate representing the petitioner.
Item number 5.
Lordship, yesterday's matter.
Madrasa matter.
Yes, Lordship.
Yes, I have directed. Why you have not served copy of the report upon the learned advocate representing the petitioner? I have directed that you serve upon Mr. Rai by 7 days from date. I thought that already advance copy has been served upon him. No, that is not the way to handle that. Mr. Mojumdar, you serve upon him.
হয়ে যাক তো দাঁড়া না
Matter relates to Madrasa education. Stop. Matter stands released due to want of determination and be placed before the bench having determination.
Lordship.
Item number 6.
I appear for this day.
Yesterday, your lordship order, I have bring this order, my lord.
I cannot hear you. Louder.
Yesterday, my lord, the matters was called on your lordship. Come with a copy of the order, similar order passed by your lordship. That in the which stage of
In this case, petitioners appeared up to which stage of
this is the
2016 upper primary selection process.
is the verification process. The name included in the interview list. My matter is different because the writ petition your lordship was pleased to dismissed. My lord, in that matter, my lord, there is no representation. In my case, my lord, there is a representation that is pending.
What you are
for-
praying, if I accept your case, in that event, commission has to conduct a fresh interview. That is not
What
permissible.
happened? Several order has been your lordship.
Where is that order? Give it to me.
But this is the only difference. I had checked the writ petition.
Fine.
My lord,
Here, have you deposited court fee?
yes. My lord, the 2006 3 SCC, my lord, this covered.
You all the petitioners appeared for classes 9 and 10.
Yes. Not the kindly. 9, 10, 11, 12. my lord.
Here petitioner's marks was above the cutoff level. Where you have stated in this writ
Yes, my
petition,
lord, kindly see it, petition.
all the petitioners obtained marks above the cutoff.
I have annexed the, my lord, the tabulation sheet.
Well, that then in this case also similar facts
Page one,
were involved.
page 124, my lord.
Page 124.
Yes.
Why you did not participate in the counseling, in the personality test?
My lord, because, my lord, that time they have got the appointment. And my lord, in the circular, clear notification is that they had not been permitted, but this is the contrary of the mother circular. But mother circular, there is no disqualification.
Another circular আছে ঠিক আছে
Yes, here petitioners preferred representation when?
Yes, my lord, kindly see the judgment.
Petitioners preferred representation when?
My lord, kindly see page 203, my lord.
May 2025. When the interview was held?
The interview held, my lord, after, my lord, the Supreme Court judgment, my lord, I made an application, otherwise, my lord, that.
So now therefore for the petitioners again interview is to be held.
No, my lord, that is not necessary. Now, subject to lordship correction, because, my lord, the entire part has.
That is not necessary.
My lord, what
Holding of
happened?
interview is not necessary.
What happened, my lord? There is the 10 marks. If without the 10 marks, my lord, they are eligible to be, my lord, the came in the zone into consideration, because their marks is without, my lord, the interview marks, the higher other than the lower meritorious candidates.
না এই দেখো এই যে ডেট ওখানে ছিল এখানে
Issue to
My lord, your lordship will permit to, my lord, one
I will
judgment, my lord.
consider it. Wait. এইখানে একটু add হবে বুঝলে? However, by preferring a representation dated by preferring a representation in the year 2025, it is alleged by the petitioners that they were not permitted to participate in the interview. Stop. হ্যাঁ বসুন। Yes, what is the judgment you are relying?
FMA 734 of 2024.
The Supreme Court judgment?
No, no, my lord. Our High Court judgment, division with Justice Tandon, the court should avoid discharge the function of the administrative authorities and should have the same for taking decision. The assertion of the power of the administrative authority is exercise of the judicial authority warranted and should be seized. My lord, in that case, my lord, the representation is pending. My lord, so many order has been passed by your lordship. No opposition has been filed till today. So, my lord, maybe the decision has been taken. My lord, this decision has been till pending, my lord. So that, my lord, the
How this is relevant?
because, my lord, the decision has not been taken by the authority.
That is in case of transfer
Subject to lordship.
in terms of, please hear this quote first, subject to. That is in terms of, that is in relation to transfer in consideration of the transfer rules. where there are several tiers created in under the statute. So therefore, before the exercise are to be considered, exercise is to be carried out by the different authorities in order to appraise, in order to consider the transfer application. Prior to that, court should not delve into the issue of that is the reasons for which transfer is preferred. Does it akin to this matter?
My lord, grateful, my lord.
Does it akin to this matter?
No, my lord, I am
Then-
subject to lordship correction, my lord. There is the
Very good.
26/7. Another judgment also, my lord, kindly consider that, but 2006 3SCC, my lord.
Petitioner is relying regarding marks, my lord. It is the self-assessment of the petitioner.
Not by the commission.
No, madam.
আচ্ছা এখানে একটা add করুন। in support of case made out by the petitioners, reliance is placed on the judgment of the Honorable Division Bench dated 3rd October 2024, passed on an intra-court appeal being FMS 734 of 2024, within bracket Shankar Das versus the state of West Bengal and others. জাজমেন্টে এখানে করে দিবে হ্যাঁ প্রাইমারি এডুকেশন বোর্ড করে দিয়েছে অর্পণ ওয়েস্ট বেঙ্গল সেন্ট্রাল স্কুল সার্ভিস কমিশন ওয়েস্ট বেঙ্গল বোর্ড অফ সেকেন্ডারি এডুকেশন মাত্র এসে গেছে কেটে দিলাম নামটা So therefore, you are disputing this allotting of marks higher than the marks, higher than the cutoff marks.
No, no, no. Obtain, my lord, from their website, my lord.
এইখানে একটা অ্যাড করবে তো প্যারাগ্রাফ 7 এ furthermore it is submitted on behalf of the furthermore it is submitted on behalf of West Bengal Central School Service Commission that whether petitioners obtained marks higher than the cutoff marks under the relevant category is required to be verified. Stop. বসুন। এখানে একটু অ্যাড করবে প্যারাগ্রাফ 9 it needs to be recorded hearing that such case made out by the petitioners relating to awarding higher than cut-off marks in their favor is disputed by the learned advocate representing West Bengal Central School Service Commission. ঠিক আছে আবার বস এসো একটা প্যারাগ্রাফ অ্যাড করবো, ওটা জাজমেন্ট রিলাই করলো on perusal of the judgment dated 3rd October 2024 passed in Shankar Das Supra, it appears same is not applicable in the present case since it was decided in the it was decided therein that before completion of exercise by the administrative authority in terms of rules relating to transfer of teachers, court should not assess the reasons based on which transfer application was made. By the applicant teacher, transfer made by the applicant. So in contradistinction to the contradistinction to the said facts at in the present case, court is considering whether court is considering when first SLST 2016 upper primary is on the verge of completion and 8 round of counseling, last counseling, 8 round counseling and 8 round of counseling is over. Whether the commission is required to hold fresh selection for fresh whether commission is required to initiate selection process again from the stage of personality test in order to accommodate the petitioners since they have lost job pursuant to the judgment of the Honorable Supreme Court dated 3rd April 2025. ঠিক আছে, এটা প্যারাগ্রাফ একটা অ্যাড হলো, যেহেতু ওটা করলো 10-এ এটাকে ঢুকিয়ে দেবো। I have considered your judgment.
But I bring another judgment also, or I not placed.
Next matter.
ABC court fee and the affidavit service.
Yes, ওপরে the affidavit service filed on behalf of the petitioner is taken on record. Stop.
Yes.
Documents are filed in support of putting in deficit put.
Item number 7.
Matters are there. এই দাঁড়াও, similar matter আছে।
Three matter.
Three matters, one after another. Yes, please call the list. Huh? 9, 10 or 9, 10, 11, 12? Only 9, 10. Confined to 9, 10.
9 to 11. 12.
In previous matter,
All matter.
but you have submitted only 9, 10.
No, subject to the.
দেখি দাও।
Paragraph 7, they have written.
Nine, 10, 11, 12 করে দিয়েছি, বুঝতে পেরেছেন? আচ্ছা, নেক্সট ম্যাটার সেম 9, 10, 11, 12 এটা রাখো শুভেন্দু।
আচ্ছা, এই রাখুন আগে। May I submit one thing?
9, 10, 11, 12 করে দেবে। আর ওই affidavit of service filed on behalf of the petitioners taken on record আর court fee same order. Next.
Next.
হ্যাঁ 7, 8 মানে পরপর ডাকো, হয়ে গেল তো।
7, 8.
এটা কত টাকা?
এটা 7.
7, 8 deposit.
ফার্স্ট ম্যাটারটা ফার্স্ট অর্ডারটা কোন ম্যাটার হলো? 6
6 months.
তারপর তো 7 হলো, তাহলে 7, 8 জিজ্ঞেস করছো কেন? 7 তো হয়ে গেল।
7.
কল আইটেম নাম্বার 8।
Item number 8.
Nine, 10, 11, 12 same order. Come up with an appropriate case like yesterday's matter. I will pass on.
She is very sympathetic in this regard, my lord, because I got several order in this connection.
But if at this stage it is found, yes, in some of the matters previously I have given direction for affidavit.
But that
It's a wrong order.
No affidavit has been filed before.
At this stage, if petitioners, if commission is directed to unsettle the inter-settled position
No, my lord,
and to hold interview appraise,
my lord,
that cannot be
maybe
countenanced.
possibly their decision has been changed. They will giving the appointment to the all candidates. That time, my lord, I lose the opportunity because
Those
that-
who participated, some of the matters, even candidates are being selected
my lord, in that case, my lord,
and recommended, selected and recommended.
my lord, no opposition means they admit. But they are not filing opposition. 4 weeks, my lord, your lordship please to direct to file the opposition. Till date, no opposition has been filed.
Yes, yes. So let me place those matters before me under the heading hearing.
Yes.
When do you want? Yes, since the issue has been decided in the meantime,
Not only my matter.
give me the, no, give me the matters. I'm fixing a date. No affidavit is required, give me the matter, particulars of matter. I'm fixing a date, all the matters to be considered on in one go.
I will take instruction from my.
Yes, take instruction, come back, mention on Monday.
তেরো থেকে দেখেই হবে নাকি? না 9, 10 থেকে।
না পরপর দেবে 9 কত অব্দি হলো? 9 অব্দি তো হলো। কি হলো বলো তো তোমার?
Item number 9.
সমস্যা কি হচ্ছে? 9 অব্দি ডাকলে up to 8 অব্দি ডাকা হয়েছে, 9 ডাকবে।
Earlier matter, your lordship observed 9, 10, 11, 12. That is
All-
not
All of them
9,
told
10,
my lord
11,
that
12
9 has been
Passed
passed.
9, 10, 11, 12.
that is
Class. What is wrong with my officer? Yes.
I have been speaking that petition of 11th RLST 2010. When petitioner joined, the petition was appointed with honors degree. Before joining the school, her last date of master degree part 2 examination got completed. 2005 GU.
Yes. Before joining, he completed the course, postgraduate course, but result was not published.
Result was.
In the relevant subject
In
of
the
case.
relevance.
Any decision is taken by the DI.
No decision has been taken.
Show me your approval memo.
That is, my lord,
That is
that is only, my lord, the
difficulty.
honors.
So
And
therefore, say he or she is
my lord,
entitled to
one
get.
thing, my lord, though, my lord, I do not.
Where is the approval memo?
Yes,
Let me consider the approval memo first. Have you annexed the approval
Yes,
memo?
yes, my lord. Approval memo has been annexed. হ্যাঁ, আমি তো দেখলাম।
No, no. Where is the approval memo?
আরে, approval মেমোটা কোথায় গেল? মেমোটা না, না, না।
English-
Page 14, page 14, first,
It's not an approval, it's a recommendation.
recommendation.
I am asking for approval granted by DI.
Liberty.
My lord,
Now, you are recommended as an English
honors,
assistant teacher under honors category,
honors.
honors PG category.
Honor speech.
But admittedly, you had honors qualification at that time when you
examine.
offered your candidature.
Yes.
Subsequently, you enrolled yourself with the higher courses and higher
No,
courses was
not
complete
subsequently. At the time of.
at the time of offering candidature by making an application before the commission. Or you were undergoing higher course of study.
I
At the
underwent.
time, you made an application under the advertisement published by the school service commission.
Yes, I was undergoing.
But when you joined, before joining, you completed the course. Result was not published.
Result was not.
So
Last
when you have joined, you
I-
should have annexed the approval memo.
that mistake.
That is the best document from which it can be ascertained that when you have joined and how you have been approved
That
and
mistake-
what scale of pay was awarded to you.
Back আছে,
Yes,
I-
when you have joined.
I joined school on 20th July 2011.
Joined on
20th July
yes
2011.
20 July 2011.
Yes.
And when the course was complete,
16th of June 2011. Page 25.
16 June 2011, page 25.
25.
না, একটাই কথা আছে।
When result was published,
Result was published on 29/9.
29/9/11,
Yes.
page
হ্যাঁ, আমার staff থেকে-
page
Page result was published of
which page?
page 26.
26 ফটোটা ছোট, amendment of ছোট,
Page 20.
20 photo amendment. হ্যাঁ, 14 যে amendment টা আছে।
Have you made any representation to the TI?
I made representation.
Where is that?
Page 30.
38.
30. 38 before the school authority. As DI told to come to proper channel. School is not taking it. Page
So let it be considered by the DI, relying upon the ratio decided in Aduluzzaman and Utpal Kanti Karan.
My lord, one thing, my lord, I want to, my lord, while consulting this, my lord, case, my lord, the amendment of 2016, my lord, he has first time paid before the authority on 2025.
So
No,
what?
no, no.
When he completed the course, amendment came into effect in 2017,
16,
2016, and he completed the course when?
my lord, much back.
in
He
2011.
Yes,
the
but-
result was, if I go by result, then result
Then
was
June.
published
June,
on
no,
29
but
September 2011.
That is not my lord.
2005 GO is also 2000. May I hand over the 2005 GO?
Not required.
In Mohammed Adil's case, it has been decided.
You have to give him from the date of publication of result. In terms of Utpal Kanti Karan, when the amendment did not see the light of the day,
That is-
My prayer is also there.
and already there is an government instruction to all the district inspector of schools to follow Adiluzzaman and Utpal Kanti Karan. File your affidavit service. Affidavit service filed on behalf of the petitioner is taken on record. Stop. Petitioner was appointed as assistant teacher
English.
in English, having honors, possessing honors degree on 20 July 2011, on being recommended by the West Bengal, by the chairman West Bengal Regional School Service Commission Southern Region. Read a memo dated 10th June 2011. Stop. Recommendation memo dated 10 June 2011 discloses that petitioner was recommended under honors PG category. Honors PG category. Stop. It is submitted on behalf of the petitioner that he was granted honors graduate scale of pay from the date of appointment with effect from 20 July 2011. Stop. Next paragraph. It is submitted by the learned advocate for the petitioner that before joining the post, petitioner completed the course of master degree in English from Calcutta University. From Calcutta University.
No,
Not the-
From Jadavpur University.
That kotha.
From Jadavpur University
Ah.
on 16 June 2011.
Netaji, oh, B.Ed.
From Jadavpur University. But he come to page 25. Course completion certificate was issued by the University of Calcutta.
Calcutta University. Calcutta. University of Art.
University.
University of.
I was dictating Calcutta University. You corrected me without consulting the paper. Yes, কি বলছিলেন? সেন্টেন্সটা বলো। (2011) and result was published on 29 September 2011. Stop. Next paragraph, it is contended on behalf of the petitioner. Since at the time of joining the post on 20 July 2011, petitioner already completed the course. Only result was due to be published. She had no occasion to pray for prior permission from the concerned district inspector of schools Kolkata, being response number 2, for enrolling herself with the university for higher course of study. So in this regard, reliance is placed on the judgment of the Honorable Division Bench passed on an intra-court appeal being MAT 825 of 2020 on 11th February, 11th February বললাম না? No, on 11th February 2021 in Adilus Zaman versus State of West Bengal and others. Stop. Reliance is also placed on the judgment of the Honorable Special Bench passed on a batch of matters, first one being WPA 9921 of 2007. Utpal Kanti, within bracket, Utpal Kanti Koron versus State of West Bengal and others, dated 7th February 2024. Next paragraph, state respondents are represented by learned advocate who has submitted that there was an amendment to Control of Expenditure Act, to Control of Expenditure Act 2005. With effect from 2016, with effect from 2016, which makes the petitioner not entitled to get the benefit of higher scale of pay. Next paragraph. Submission made on behalf of the state respondents ought not to be countenanced since petitioner completed postgraduate course on 16 June 2011 and result was published on 29 September 2011, which was before aforesaid amendment relating to Control of Expenditure Act 2005 was promulgated. Stop. Said amendment not having retroactive operation does not empower state respondents to deny benefits, to deny benefit of higher scale of pay to the petitioner if petitioner is found to be eligible otherwise. Next paragraph. A representation is made by the petitioner dated 20 March 2025 addressed to the respondent number 2 seeking sanction of postgraduate scale of pay. Stop. Respondent number 2 is directed to take decision on such representation within a period of 8 weeks from the date of communication of this order after granting opportunity of hearing to the petitioner and the school authority or their representatives. Stop. Respondent number 2 shall pass a reasoned order on following the ratio of Adilus Zaman Supra and Utpal Kanti Koron Supra. Stop. The decision to be taken by the respondent number 2 shall be communicated to the petitioner by 10 days thereafter. Next paragraph. Writ petition stands disposed of urgent xerox.
Item number 10.
Yes.
petitioner is an assistant first as a headmistress and retired on 30th/11/2024. Since then, she is not getting his pensionary benefit due to
When retired?
but 30th/11/2024.
4. 30/11/2024. Retired. Headmistress.
Headmistress. My lord, he is not getting her salary on the grounds of the observation made
Salary.
pensionary
Pension.
benefit due to the observation made by the DPPG, Director of Pension and Provident.
Who is appearing for the state?
Code of shame.
Where is he?
Just here.
Well, inform him not to be. Take back your affidavit service. Because the issue has to be decided in presence of the learned advocate representing the state.
Well, the state is giving deputy director is giving observation in my
Inform
favor.
him, inform him.
Yes.
Not today. Yes. Who?
Led by Mr.
Who is engaged?
Mr. Fitos,
Where is he?
Lordship. That's why I'm praying for not today, Lordship.
At the time of call, accommodation is paid for on behalf of the petitioner. However, West Bengal Central School Service Commission is represented by learned advocate. You are for the state.
No, my lord.
However, West Bengal Central School Service Commission is represented by learned advocate. Stop. List the matter under the heading motion in the monthly combined list of September 2025. Next.
Item number
I appear for the state, your lordship.
Respondent number 3. Who is for the petitioner? You are for the state.
I am for the state, your lordship.
And for the respondent was the headmaster.
Headmaster.
My only allegation is, my lord, before the headmaster. Again, the headmaster, my lord.
Teachers representative election you are challenging. Who are you?
I am the teacher, my lord, parties who contested in the same election process.
The election was held on 20th April 2025. It's a government sponsored institution. Who is for the board? Have you made board as party?
Or yes, my lord. One or two. 1 and 2.
But I don't think copy has been served.
Show me that this copy is served.
Board has only some.
That is the reason, Lordship.
Board has to be directed to take decision. Though now the procedure for holding election is not applicable in government sponsored institution. But if you are raising an election dispute, that has to be considered by the board.
Cannot deny that. Is, my lord, kindly give
Uh,
short date, my lord, I shall
Matter
have the
is, learned advocate representing the petitioner has prayed for accommodation to effect service of notice upon. President, West Bengal Board of Secondary Education being respondent. Stop. Let no service of notice upon the respondent number 2 be effected by 7 days from date and affidavit of service to be filed on the next date. Stop. List the matter under the same heading on. 21st August 2025.
Next, grateful to your lordship. Item number 13.
Was appointed as a teacher in class 9 and 10, but under the subject is graduation. Now, before her appointment, that were in the upper bracket. During subsequently got appointment in the assistant in 9 and 10. However, she called for interview. She went for interview, but she was not allowed to appear in interview on the ground that she is an insufficient candidate. Now, your lordship and the other honorable coordinate benches has passed a mini order that your lordship also passed an order, thereby directing the board, the commission, the school service commission, to allow them to appear in the interview. Not my case, in other case. And you also further directed to file opposition. And now, since I am not allowed to participate in the interview, I raised a grievance. My grievance was considered. So let's kind of see my grievance once. That is page 42. The relevant is page 43. Page 40. She has been serving at HPSR Beliyata Vidyalaya, Raniganj, Uttar Dinajpur, as assistant teacher as per memo number so and so. Candidate cannot apply for the post in same or below pay scale. Hence, her candidature will not be entertained since the authority found her as in-service candidate, though she is qualified as per merit list. Forwarded to the secretary CSC to confirm please. Number, kindly see the note of the
When this order was passed?
Passed on 30th September 2021. But kindly see the note.
Why you are coming today?
Yes, madam.
After,
Before that, but kindly see the note.
After 5 years?
But kindly see the note of the secretary. Secretary says, for number of similar other cases, there
Where secretary says?
The pending adjudication in the Honorable High Court, the fate of the application could be determined on the basis of the similar other cases. But my case was not fully shut down. The secretary is pleased to hold that since the other matter is pending to the Honorable Court, my fate will be considered.
When this endorsement was made?
But so endorsement was on sometime at 18-1, but I can't get the exact date. It was
18 January, then?
Maybe 2022, because September it was hearing was held. So my case was not fully shut down.
Yes, Dr. Patro. What about this endorsement?
My lord. Regarding the endorsement, I will have to take instruction.
Take instruction.
Regarding what was the fate of.
Why this endorsement was made?
Yes.
Because he contemporaneously petitioner raised a grievance.
No,
And
this grievance.
Dispute was raised.
My lord.
And this dispute was the complaint of the petitioner was decided on 30th September 2021, but with a rider.
This grievance which the petitioner has raised is not a grievance which was voluntarily made by the petitioner. These were the grievances which we accepted pursuant to the direction of the division bench. When 18,000 candidates were all invited, that if you have any difficulty, those who have not been called for personality test, you may raise your grievance. On that basis, this grievance was raised. That is why it is in our format. Then the petitioner comes with this grievance, intimating the grievance.
So, are you submitting that without raising grievance, it was automatically considered?
No, I'm not saying that. What I'm saying is
this grievance redressal was an exercise in terms of the order of the Honorable Division Bench.
Yes.
But that redressal was required since a dispute was raised by the petition.
No, these grievances were entertained pursuant to the direction for those candidates who were not called for personality test. So those who not being called for personality test but felt aggrieved, they were permitted to
Raise grievance.
make representations.
So representations were made,
Yes, yes.
and based on which this decision was
Yes,
taken by
yes,
the authority
yes,
that yes, since you are working in a post which is attached to higher scale of pay,
So you cannot.
therefore you are not
Yes.
entitled.
Yes.
But that was with the rider.
Yes,
that
but
the
this rider has
fate
come
of
much
the
later.
applicant would be determined
Rider
the
came
basis of
much
similar
later.
other cases.
You know, that rider has come much later. That is why I would like to take the
Obtain
instruction.
instruction.
There's a 4-month gap between the reasoned order being passed and the rider being added. That is why
How
I.
it was added, how it was added.
Yes. It is the signature of the
This was
secretary.
not required in terms of the judgment of the Honorable Division.
And I will look into it.
And in other matters where deciding the issue, where many matters, petitions where decision of the grievance redressal committee was under challenge, were under challenge, and there I did not find this kind,
No,
this
This is the
rider,
first time I'm.
this condition.
In the report of the state order to the secretary PSC to confirm.
Very well, you obtain instruction and come back.
Yes.
Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner raised grievance before the grievance redressal committee or grievance redressal authority, which was in connection with not permitting the petitioner to participate in interview relating to first state level selection test 2016 upper primary. Said grievance was decided video order dated 30th September 2021. But there was an endorsement made by the Secretary of the West Bengal Central School Service Commission stating fate of the applicant would be determined on the basis of similar other cases. Stop. Next paragraph, Dr. Patro, learned advocate representing the commission, representing West Bengal Central School Service Commission, has prayed for accommodation to obtain instruction. Next. List the matter under the heading, under the same heading on 21st August 2025.
Hello, now I file a report. Because even if the notice there, whatever was the result in the other litigation, whether the petitioner will get the benefit, and that too he delayed so long.
Has prayed for accommodation to file a report. To file a report, concerned authority of the commission is directed to file a report in the form of affidavit by 2 weeks from date. Stop. List the matter by 2 weeks from date, and a copy to be served upon the learned advocate representing the petition. Stop. List the matter under the same heading on 28 August 2025. 28 March. Next.
Item number.
Yes.
Joined as assistant teacher of geography in the year 2030, December 2030. Completed 5 years in 2018. 2021 not applied for general transfer not after completion of 5 years for this on portal on distance ground as well as not health ground. Now not twice application was made. The school managing committee under the rules they have to forward it. They have to shall issue NOC and forward it to the DI. DI will consider. They returned it to the applicant. Only school. Only ground could be if it is more than 10% of the total teacher strength. That is the only ground available. That was not the case here, but they returned it.
Where is the status?
Status is not at page 27.
Lordship, similar. It only says as per decision of taken unanimously by the school managing committee, application of Soumi Patsu for general transfer has been sent back to the applicant without disclosing any reason. 2022, my lord, she gave birth to a child. Child is also extremely ill. Rule was
Twice you have made application.
twice made.
On 11th August first,
My lord.
subsequently on 29th of August.
Both cases, my school did not forward.
Now, if you are not coming, if you are hit by 10% rule 5, rule 6(5), then you are not eligible.
It is not the case, not that 10%.
That more than 10% of the teaching strength, teaching staff cannot be allowed for transfer. It is a specific provision in the transfer rules of 20.
This is not the rule.
Yes.
Can it takes up the rule and the amendment, my lord?
Yes.
This is not rule.
Who is appearing for the school authority?
School
authority has to be hard because your grievance is against the school authority.
If they can satisfy your lordship that I am.
How you have served upon the school?
But I have served by post, my lord, they have received.
Doubt. Without.
I can give that to the lord.
Because primarily your grievance is against the school authority.
They are not forwarding. That is the matter. Headmaster. Yes. TIC. 6 and 7, my lord. The headmaster and the.
When served, Mr. Banerjee?
Delivered on 7th of July 2020.
July.
7th
July. Serve another notice. And I will direct who is for the DI. I will direct the DI to submit a report. But in many cases, school authorities are not represented. All matters direction upon the police authority is not warranted. That's why I am directing a DI, but you serve a notice upon this.
There was an amendment subsequently in 2021. Some more grounds have come up. If there is a disciplinary or judicial proceeding, then also school will not.
So that is not the issue as you are submitting. No proceeding is against you.
No proceeding is against me.
Now, if there is augmentation of staff strength, suppose there are 30 teachers working in the school, 10% would be permitted to take transfer. Means 3. Now, if there is 25, then it will be rounded to the next higher digit. Then 2.5 will be rounded up to 3. But once it is done, I have delivered a judgment. Then subsequently in each academic year, that cannot be done unless there is augmentation of staff strength by transfer or by new appointment. So if staff strength is constant after permitting 10%, then you are not eligible. But if there are transfers and there is augmentation, in that event, school authority has to consider it again. So what is the present position with regard to the staff pattern?
I'll
that
come
has
back
to be
with
considered.
specific instruction and a supplementary affidavit giving the staff pattern and the what is the position. Not
issue.
2 more grounds have been added. One is not that judicial proceeding, which is not the case. Another is not if the subject strength becomes.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner, and another question is there, why you are coming after 4 years?
So, then 2022, she gave birth to a child. Another application was made not in prescribed pro forma. That has also been kept pending because the child is also.
No, but today court is considering your 29th August 2021 application. In the meantime, 4 years have passed.
True, but after childbirth, my lord, because of the ill health of the child, another application was made. All 3 applications I have not mentioned and I have annexed. The subsequent one also after amendment, some additional.
So you have to take a decision which one you are pursuing.
Subsequent, because the child now it's a question of 2-year-old.
But
child.
Giving birth to a child is not a ground for transfer.
No, the health of the child. The child is extremely ill.
So that has to, in that event, it has to be considered by the block medical officer of health and subsequently by the chief medical officer of health.
I will consider whether or not the condition.
So then the process is completely different. If it is on the ground of, you please make up your mind.
I understand.
But after this exercise now, if it is found that no, you are not eligible, then you will say, no, I have subsequently made an application on medical
I
ground
understand.
of my
I
child.
understand. I have to take
So,
a,
so therefore that application should be considered,
I
then court will not permit.
I
Now
understand.
today
I'll
you
have to
make
prove.
your submission that whether you are interested to pursue
21.
remedy based on your transfer application dated 29th August 2021,
Fine.
or you want to pursue a remedy based on your application on the ground of ill health of your son.
I'll take specific instruction and I'll
Then
choose.
first come up with an instruction. Because the two procedures under the rules are completely different. If it is on the health ground of your son, then it has to be the son has to be tested by the BOMH at the instance of school. Then at the instance of PI by the by the concerned medical officer or medical board, chief medical officer of health. Then if the report comes in your favor, then you will be transferred, otherwise no. So which application you are pursuing?
And the previous one only difficulties is 2021 it was returned.
No, you follow what court is asking.
Fine,
So you tell me that which one you would like to press before this court.
I'll take with specific instruction and I'll come back. If we'll have to fixes a date, I'll come back with the specific.
Rather withdraw the writ petition, file fresh application.
Not fresh application, not 21 has been not
File fresh
now,
application in the prescribed format. In the prescribed format, yes, portal is allowed, court is allowing. Court is allowing that even if portal is suspended, right of transfer which has been guaranteed by the statutory rules cannot be taken away. There is a judgment of the division bench and this court.
It may come back tomorrow because the application which is made subsequently, it is a I find page
Not
44.
today.
It is for general. I'll come back to
Not today. And in many cases, now teachers are withdrawing their writ petition with a leave to file afresh in accordance with law. Then you can file an application in prescribed format and that has to be processed. So therefore take an appropriate stand before this court. Once I direct the DI to submit a report, thereafter you cannot switch over from the application which was made on the ground of distance to an application made on the ground of on medical ground of your son. Follow?
Fine.
So therefore come back, obtain instruction. Take back the rules and take back your affidavit service, simply not today. Or hearing of this matter stands adjourned, not this week. Not this
I'll
week.
come back.
Not this week.
Extremely grateful, man.
Not this week, somewhere. Item number 15.
No, I appear on behalf of the state respondents.
Higher scale of things on the basis of the special bench judgment.
The
service.
my instruction is this, my lord.
Decision by the DI.
Yes, my lord. This is the, my lord. I have got the decision. I have got the instruction. He is not entitled because
Whether a DI has taken it.
no. The decision has not been taken.
Why he is not entitled?
Because, my lord, your lordship knows that in terms of, my lord, paragraph 72G of the special bench judgment, it says, my lord, your lordship knows, if a teacher has partially completed her study before entering the service, she would come under the purview of GO December 2005. Partially completed her studies
Yes.
before entering into the service.
Yes,
Here,
then he is entitled.
then he is entitled. But here in this case, he completed his entire her studies after entering into the service.
After
Entering into the service.
in that event, what is the scope for obtaining permission under 7 November
But
2007 circular?
but in that score, my lord, paragraph.
I can understand, Mr. Mitro.
Lordship, my
Apply
lord.
your mind.
Yes.
Suppose a teacher
Yes.
possessing postgraduate degree,
Yes.
suppressing that degree applied under honors PG category, that will not inure to his or her health, because the standard of assessment is same for honors and PG candidate.
Lordship.
So nobody will do this.
Yes.
Which will not inure to his benefit in terms of sanctioning pay scale.
Lordship.
Now, if on a particular point of time, if a teacher is applying for under honors PG category, but admittedly that teacher does not have postgraduate qualification, then based on the candidature, based on the selection process, petitioner is selected. During this period, when this selection process was going on, if petitioner completed or completes higher course of study and obtained qualification, In that event, what is the scope so far petitioner is concerned to obtain prior permission?
Lord, here,
Why Adiluzzaman and Utpal Kanti Karan will not apply in that case?
Lord, she has joined the school in 2006 and completed entire course of MA, Lord, in 2011.
2011?
Yes, and by dint of paragraph, Lord, 272A,
When course started?
In 2009 and completed in 2011.
and
Then have to obtain permission.
yes.
Degree, Lord. She's having.
So in that case, it is not a case of Adiluzzaman.
Yes,
Then the DI to take a decision.
Yes, Lord,
Where
in
is
terms
your
of
approval?
paragraph A, Lord, give a special bench judgment.
Where is the approval?
This is the instruction of the DI, Lord, relied upon the special.
Where is your approval memo,
Page
Mr.
90.
Dey?
Page 90.
90.
19.
19.
March 2006, you joined and approved.
Yes.
And you were approved.
Yes.
Now, when you completed the course?
Completed. Then next page, my lord, page 20.
2011, Lord.
2011.
2011.
I sought for permission, then completed in 13. And
No. When you completed the course, where is the document of the university?
Yes.
School permitted you. That will not cut any eyes unless and until
Yes.
permission is granted by the DI, prior permission.
That has not been taken, my lord.
2013, I completed.
Where from court will find it that in 2013 you have completed? Yes, page 25.
25, my lord.
25.
Issue. Let a decision be taken.
Lordship, my lord.
Now, have you made any representation?
Yes, representation is also there. At page 24.
Headmistress made a representation. Where is your representation?
It has been sent through school only.
You make a representation within certain time, that will be
Yes,
considered by
that
the petitioner. Affidavit filed or affidavit service. Affidavit service filed on behalf of the petitioner is taken on record. Stop. Petitioner is an approved assistant teacher in a secondary school with effect from 7th March 2006. Stop. At the time of granting approval, petitioner was sanctioned honors graduate scale of pay. Memo, honors graduate scale of pay. Stop. Petitioner subsequently enhanced her qualification, her educational qualification by obtaining postgraduate degree in the relevant subject of teaching in 2013. Stop. Petitioner prays for sanction of postgraduate scale of pay in consideration of her postgraduate degree. Stop. It is submitted that school authority where petitioner is working at present permitted the petitioner to undergo higher course of study, and after completing the course, school authority forwarded the issue to the district inspector, to the additional district inspector of schools AC Durgapur subdivision, it is Paschim Bardhaman. Additional district schools AC Durgapur subdivision, Paschim Bardhaman, for taking steps, but till date no steps have been taken. Next paragraph. State respondents are represented by learned advocate who has opposed the prayer of the petitioner on the ground that before undergoing higher course of study, petitioner did not obtain prior permission. Next paragraph. Having considered the respective submissions made on behalf of the parties, this court finds no useful purpose would be subserved in keeping this writ petition pending. Stop. Next paragraph. Leave is granted to the land advocate for the petitioner to make a representation to the district inspector of schools. To the district schools AC Poschim Bardhaman being respondent number 3 by fortnight from date claiming higher scale of pay in consideration of petitioner's postgraduate degree. Stop. If such representation is made within the aforesaid time, respondent number 3 shall decide the same in accordance with law within a period of 8 weeks thereafter, after granting opportunity of hearing to the petitioner and the school authority or their representatives. Stop. Respondent number 3 shall pass a reasoned order and same shall be communicated to the petitioner by fortnight thereafter. Stop. Writ petition stands disposed of, urgent settlement.
May I take back, my lord?
Yes.
Service.
Open avenue service.
Extremely grateful.
Item number 16.
At the time of call, accommodation is paid for on behalf of the petitioner. List the matter under the heading motion in the monthly combined list of September 2025. Yes, next.
Item number 17.
Before the statement. Here, my lord, there were 2 rounds of litigation earlier, my lord, and my lord was pleased to release the matter. Because the school concerned, my lord, kindly see respond number 8 and 9.
Who was released?
My lord released the earlier round of litigations. But kindly see, my lord, respond number 8 and 9.
Respond number 8.
8 and 9.
Yes. Issue. Writ petition stands released on personal ground and be placed before the Honorable Chief Justice for assignment.
নাম দিয়ে যাবেন সবাই। Item number 18.
Not clear. So, Lordship has dealt with these issues. Here, my lord, because this one, I did not participate in the upper primary council since I was in 19. Cancel your lordship in a matter of 4/7 was not yet conducted.
You participated in the interview.
I was very pleased. I was called for counseling, I could not. In a similar matter, your lordship allowed for counseling since 7.
Mukti Vishwas.
Yes, yes. Again,
Yesterday I passed an order, Dr. Patru.
one thing. I should not place the entire facts in another matter. Similar circumstances, your lordship master direction for affidavits.
But now I am not giving any direction for affidavit or filing a report. I am disposing of the matter, permitting the petitioner to participate.
Because
Which was objected by your learned friend. Since in previous matter in Mukti Vishwas, I gave.
One prayer I will make today. Yesterday I missed it.
Only one thing, where your lordship of there, because their submission that they are planning to conduct no more counseling on 2nd of August.
Yes, that I know. I know the development. Justice Rai directed that the subsequent round of counseling is to be conducted.
Yes.
And that was brought to my notice when I was on circuit and sitting in the circuit bench, I passed order, relying upon order passed in Mukti Vishwas as well as by Justice Rai. Yesterday's order.
My lord, only one thing. Allowing to appear in the next phase counseling, this order was first passed by Justice Aniruddha Roy. He had kept one rider, his lordship. That is that subject to the availability of a vacancy, because when the vacancy was there.
I said if he comes within the zone of consideration.
No, the candidate might be within the zone of consideration, but there might not be a vacancy.
So that consideration must be based on the vacancy which are available.
Kindly make it clear. Kindly make it
that right. Yesterday's order.
Counseling will be called if there is.
Relying upon Mukti Vishwas, I passed an order yesterday.
Yes, but that order I don't have.
It is not on server. I signed the order.
I didn't check.
বুঝতে পেরেছো?
মুক্তি বিশ্বাস I have.
বার করো না। কত নাম্বার? তাহলে আবার আমার নতুন করে ডিকটেশন দিতে হবে। দেখো রিলাইং আপন মুক্তি বিশ্বাস দেখো। That I'll help you. Because what is the ratio? 1:1.4.
Yes.
So if there are 50 vacancies, then at the ratio following the ratio of 1:1.4, candidates are to be called for counseling. Now that is why I have consciously directed that if petitioner comes within the zone of consideration.
But kindly make it clear that
even there is, it is not made clear.
No, because the situation might be arise. It might be interpreted in such a manner that I am within the zone of consideration, but the commission does not have a vacancy to give. But when we had the
If
vacancy.
if there are 10 vacancies,
Yes.
then 14 candidates are to be called.
Yes. Yes, but only 10 will get.
Only 10 will
Only
get.
10 will
So
get.
the 14 candidates will be called for interview, will be called for counsel. So if in terms of merit, petitioner does not come within the ambit of 14, he has no right.
Kindly make it clear, because in some categories now all the vacancies are exhausted also. So I will not even be able to call them in the true sense.
This is the order yesterday passed. Down. Class 9 10 SLST. Single petitioner.
নয়টা disposed of, 8টা dismiss. Those not today. এটা 10 number. নামটা দিও।
Have you annexed the merit list after your participation in the personality test?
Is that 8 my lord 6? It is 0 to 0 my lord. I am 1. And my lord, this is one rank. Again, my lord, 8, 6, 61 different multiple ranks.
Multiple ranking under different category.
Different category. And my lord, 62, kindly see call date for call for council. 62. Okay. So not this one. Somebody. Another disposal. লক্ষ্মী পুজোর পর যায় তীর্থ তীর্থ এই
Do you have you filed order in past in Mukti Vishwas? একটা মুক্তি বিশ্বাস বার করে নাও তো, এটা ইয়েতে রিটেন করবে অর্ডার রেকর্ড 9980 of 2025.
My lord, I have.
Yes, it is there. Check it out.
লিখতে তো নামটা, এই নামটা দিতে বল অমিত চেঁচাচ্ছে, নামটা দিতে বল অমিত চেঁচাচ্ছে।
Petitioner is still working.
কিছু
ইয়েটা নিয়ে যাবে তুমি।
ম্যাটার আছে। জানি জানি
Subject to availability of vacancy, I have included. এই শোনো,
Order of the division bench is upper primary matters. Upper primary matters. Here, my lord, the division bench has specifically directed that everybody should be given appointment, and for that, consent. So, my lord, if you're subject to correction, I will.
that 24,000 and all.
Yes. No, no, that
14,052.
14,000 and all.
Everybody who is in the panel should be given appointment. That is the specific.
But division bench did not say that absent candidates will come back in spite of a statutory bar and participate again.
I am an impanel candidate, I am covered by that division bench observation, I am covered by that.
That we will reply in the content. That my learned friend need not worry
And
about.
they have not preferred any SLP or reviewing.
এটা থাকতে শোনো এখানে
No, no, we have filed a review. You are not aware of it. Have to step that to them.
action আছে disposed of. Will be permitted to participate.
My lord has,
এইটা মুক্তি বিশ্বাস। এটা এখানে থাকবে।
my lord has recorded subject to availability of the vacancy. Deeply obliged.
Item number 19. We are frustrated.
Yes. When you have retired.
Well, the retirement is on 31st January 2025. Whether the amount was recovered on the 6th of February 2025.
Where is TR form?
Page 48.
When it was refunded 18 February 2025.
Yes.
So after refund you were a pension payment order was. So why you have refunded? Why you have refunded? Why you have not come at that point of time?
My lord, they refunded, my lord, it was understood by them that
I will give direction for affidavits, come back. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Assistant teacher.
yes, my lord.
Petitioner was an assistant. Petitioner was an assistant teacher. of a government aided school who retired on superannuation on 31st January 2025. So, while processing pension case of the petitioner, state authorities found that excess amount was drawn by the petitioner and demand was made by the state authorities from the petitioner to deposit excess drawn amount before finalization of pension case. Stop. Accepting such demand, petitioner deposited alleged excess drawn amount on 18th February 2025, based on which pension payment order was issued on 5th March 2025. So, subsequently, petitioner has filed this petition for refund of amount which was deposited by the petitioner on as per demand of the state authorities. As per demand of the state authorities. So, next paragraph. Issue needs to be decided on exchange of petitions. Next paragraph. Let affidavit in opposition to this petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be. Have you served upon the school authority? Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Stop. Learned advocate for the petitioner is directed to communicate this order to the non-appearing respondents by 7 days from date and file further affidavit of service. That will be decided finally. That you could have challenged at the time when demand was laid. What you did, you accepted the demand, deposited the amount, got the pension, and thereafter you are coming before this court. That is not appreciated. So that's why affidavit. You are coming under paragraph 18 of Rafiq Mashi, but your conduct is not appropriate. When you are coming before this court, you could have raised this objection while this demand was laid by the state authorities. In similar other matters, I have passed same order. At least I have had more than 50 matters. Had you approached this court at the right moment when demand was made, court could have passed a final order. First you took the pension. Yes, and thereafter you are coming, yes, refund me. Because I am protected by the ratio of Rafiq Mashi. Yes.
Item number 20.
Service is not. When you have started, you filed it on 26th April 2025. So till date service is not complete, who will believe it? No. Issue. At the time of call, learned advocate representing the petitioner prays for accommodation to complete service of notice upon all the respondents. However, state respondents are represented by learned advocate. Next paragraph. List the matter under the same heading on 9th September 2025 in order to enable the learned advocate for the petitioner to complete service of notice and file affidavit of service. Great. Next.
Item number 20.
Grant of family pension. Where is the order of the district? Is 2010 order.
30th, page 20.
No, just a minute. Page 23. What is the wrong in the order?
As considered two aspects of lordship. First, the teacher was an organizing teacher. He started in the school since 1st January 1970. And one for grant of family pension, 1 year active service is required.
No. No, that has been stated in terms of DCRB scheme, it is 10 years. 10 years. It is 10 years. In terms of DCRB scheme, it is 10 years required. For pension, 10 years. Family pension, 1 year. But in terms of this order, this is it says specifically because husband of the petitioner died prior to 1st of April 1981. And after rendering service of 7 months, 25 days. And two circulars have been were relied upon, which says that if an employee dies in service after putting in service between 5 to 20 years, his family will be entitled to a gratuity of 1/4.
That is old pension scheme. But my lord, pursuant to notification dated 1st November 2010, the teaching and non-teaching staff who retired or died prior to 1981, they are covered. They are covered under the DCRB scheme.
So even if DCRB scheme is applied, you are not coming.
But if the CRB scheme applied in my case, your lordship, and the organizing period is considered. My lord, this department. In many of the
Affidavit of service filed on behalf of the petitioner. Who is to prove that how many years you put in as organizing teacher? Where is the DLIT inspection report?
I have annexed a resolution of your lordship.
Resolution will not do. Where is the DLIT report? In 70, prior to 74, you worked as organizing teacher. We will believe it now. How it will be substantiated?
School authority can.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph. Petitioner's prayer for sanction of family pension has been turned down by the District Inspector of Schools AC Hooghly vide memo dated 30th December 2024. Stop. While taking decision by the concerned District Inspector of Schools, it was found that husband of the petitioner served for 7 months and 25 days from 1st January 1974 to 25th August 1974. Stop. Applying relevant circulars. Length of service of husband of the petitioner prima facie was not found to be a requisite period. Which is necessary for sanctioning family pension. Next one. Stop. Hence, next paragraph. Hence, take it down. State respondents are represented by learned advocate. Next paragraph. Issue needs to be decided on exchange of affidavits. Let affidavit in opposition to this petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging. No, sorry. No. Next matter. Item number 22. Already it has been considered by the DI in terms of the previous order passed by a coordinate bench. Sorry. At that point of time, you should have pointed out that instead of DI, it should be by the principal secretary.
But in this matter, my lord, I am appealing for the petitioner, my lord. I am led by Mr. Fogo. My lord, here the petitioner's grievance is, my lord, for the arrear of salary, my lord, and the approval, my lord. Approval, my lord, since April
for the state?
2025,
My lord, for the state, I'm led by the learned GP.
my lord, since April 2025, my lord, the petitioner has repeatedly, my lord, given representation, my lord. Even the headmaster of the school, of the college, my lord, of the school, my lord, has given
What you are paying for arrear salary?
Arrear salary from April 2025 to till date, my lord.
You are not getting salary now?
No, my lord.
You are working as?
Working as assistant teacher in philosophy, my lord.
Now, why you are not getting salary?
My lord,
My lord, he was working in one
my
particular
lord, joined
school.
the school
Then he
7th.
passed an exam and joined another school. So since joining from April, the salary has been
stopped.
Why?
I was
Do you have any
transferred,
instruction?
No, my lord, I need some time for instructions.
Why he joined another school on transfer?
No, my lord, he passed an exam.
My lord, I joined the schools transfer, my lord. Transferring from, my lord, Purulia.
Where is the transfer order?
Memo dated.
Page 4.
My lord, annexure P4, my lord.
P4.
My lord, page 25, my lord.
So after transfer, you are not getting salary.
My lord, after transfer, my lord, I joined the school, my lord, and after that, my lord, since April 2000.
When you have joined?
My lord, I joined on, my lord, 5th April 2025, my lord. Fifth March 2025, my lord. I applied for
April
the
you joined.
My lord, 5th March 2025, my lord.
5th April 2025 you joined.
My lord.
Have you obtained release order from previous school?
Yes, my lord.
Where is the release order?
My lord, I'm showing. My lord, Annexure P5, my lord. My lord, page 26, my lord. Page 27 is the release.
Have you made previous school authority and present school authority party?
My lord. But the present school, I have made the headmaster as a party, my lord.
No,
But
previous school authority has to be made party. What has happened? That's why you are not getting salary. There must be some loopholes. Otherwise, it normally it doesn't happen. So add this Purulia Netaji Vidyapith as party additional
My lord,
respondents
your
or
lordship may
come
kindly
back.
leave. Yes.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. It is submitted by the learned advocate representing the petitioner. That petitioner was transferred. Video order dated 27th February 2025 from Purulia Netaji Vidyapith to Madhubon Goenka Vidyalaya, Bakura. But after joining the post on transfer on 5th April 2025, petitioner has not been getting salary. Next paragraph. Leave is granted to the learned advocate for the petitioner to amend the cost title and add Purulia Netaji Vidyapith Purulia and its and head of the institution of the said institute and the head of the institution as additional respondents in course of this deed. So after amendment is carried out, learned advocate for the petitioner is directed to serve notice upon the additional respondents, enclosing amended writ petition, copy of the amended writ petition and the order passed today by 10 days thereafter, and file further affidavit of service on the next day. Affidavit of service next paragraph. List the matter under the same heading on August 28, 2025. Next paragraph. 28. District Inspector of Schools AC Bakura, being respondent number 5, is directed to file a report as to why petitioner is not getting salary after joining the post on 5th April 2025 on transfer, on the next date.
My lord, even the my lord, approval is also pending, my lord. No approval has been.
Now you are saying
no, my lord, I have my lord.
You will not get salary unless until it.
My lord, that's why my lord, the approval is pending to the DI. My lord, I've made several.
You are practicing.
My lord, 6 years, my lord. My lord, I have.
This is the performance.
No, my lord, I have my lord submitted, my lord, that the approval has not been given, my lord.
You are practicing in service law. It's very difficult to believe. Boso. That is the reason. Since approval of appointment has not been accorded by Bankura DI, you are not getting salary.
My lord.
But my lord,
My lord, at the starting, my lord, I submitted that the approval is pending, my lord.
no, I was also asking to your learned friend representing the state that do you have any instruction? He has prayed for time to obtain report or to obtain instruction. And now you are saying that no approval.
My lord, I apologize.
Difficult to run the court if this is the standard of assistance court is getting.
My lord, I apologize, my lord, for that.
See the wastage of time.
I apologize. I tender apology, my lord.
Have you prayed for grant of approval?
My lord, my lord.
Issue. What was the order taken? Due to want of approval. Due to want of approval, which is required to be accorded by the District Inspector of Schools AC. Bankura being respondent number 3. বাদ বাকিটা সব কেটে দাও। হ্যাঁ। Client advocate representing the state respondents is directed to obtain instruction as to why till date approval of appointment has not been accorded in favor of the petitioner after joining the post on transfer on 5th April 2025. Stop. List the matter under the same heading on. August 2025.
Deeply obliged. My lord, I tender apology, my lord. Forgotten, my lord.
Item number 23.
My lord, in item number 23, my lord, I am appearing for the state respondent. My lord, today I have a very unusual request for praying for accommodation, my lord. If your lordship kindly be pleased to keep the matter on next Monday, my lord, it will be convenient for me, my lord.
Not this week.
I'm deeply obliged, my lord. I'm deeply obliged, my lord.
Yes, Sommar. আচ্ছা একটা record and order. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Client advocate representing the state respondents appears on virtual mode and has prayed for accommodation.
My lord.
Stop. Hearing of this matter stands adjourned till Monday next. 11th August 2025.
My lord. Grateful, my lord.
Item number 24.
I appear for the petitioner in this matter. Appointed under past SLST as a physical education science, physical science teacher. Joined in 25th of January 2019.
Physical science teacher.
Physical science teacher.
So your appointment goes.
That is why I am before your lordship. You appoint control. Should I, my lord, come to get it and rescue from a lord? Simultaneously, my lord, I succeeded in upper primary.
2016 upper primary. Succeeded up to what extent?
Succeeded appointment letter issued.
Oh.
Recommended but did not join.
Not only
When
recommended,
recommended?
appointment letter was given.
When recommended?
Recommendation, page 32 is a recommendation.
Show me the recommendation memo.
Yes, page 32.
32?
Yes. In the upper primary.
Have you prayed for extension of validity of recommendation? When you have prayed for?
Immediately, my lord, after the
What is the letter for
Lordship will
self-
kindly look at the letter for appointment letter has been given. Request to remain present on the school for necessary verification. Page, next page. Next page on
the
letter of
material point
appointment.
of time, Mr. Bhattacharya, you did not join. Because you are working for 9, 10 or 11, 12.
9, 10.
90. So you did not join.
No.
Now you must have applied after 3rd April 2025.
No. Before that.
Before that.
Before that, I made the prayer.
Where is the prayer?
Page 37.
Page 37.
18th of January 2020. 24th December recommendation. Appointment letter. 18th January 25, my lord, I applied.
16 January or 18 January?
Left hand side.
16.
16. ওটা পড়া যাচ্ছে?
16. 2 days before. Now it was received by the authority.
It is sent by mail. The next page, Lordship will get it. Page 38, it was sent also in speed post. But the pure science teacher, there is no waiting list. I have averred in the petition. There is no person, my lord, is working there. The vacancy is still continuing. There is no math teacher there. I have nominated. I am getting salary.
Now, in case where candidates are approaching the commission for extension of recommendation within the period of 90 days, then I have passed an order directing them to join.
Lordship, in this matter, similar matter, where the
In previous
candidates are
matters?
recommended, my lord.
Yes.
In such matters, the Lordship is directing us to take instruction whether the school in which the petitioner is recommended is still vacant or not.
Very well obtain instruction come back.
Yes, ma'am.
Because in 1 or 2 matters, I have given direction if this approach is made within 90
Within
days.
90 days to
In
consult
terms
by
of
the
section
chairman,
70, rule 17(3).
Yes,
In that event, already I have passed an order
Directing the
permitting
chairman
the
to
petitioner
consult.
to join, subject to availability of vacancy.
Vacancy.
To obtain instruction come back. Because here, this recommendation was made on 21st November 2024.
Yes, my lord.
And petitioner, though not in very clear terms, but petitioner made a request to the secretary. Oh, this was a request to the teacher in charge of junior high school.
He
It was
made
not to the
representation
commission.
This is forwarded to the, because he has given him the letter of appointment.
Commission in
Recommendation followed by an, I have made, that is not
is
within 90.
39, my lord.
But the next page,
No,
the
no,
commission.
Mr. Bhattacharya, that is not to the school authority, not to the commission.
First of all, my lord, the
Very well, let me dispose it of directing the commission to take a decision in terms of proviso to rule 17(3). Because there is a provision to extend the recommendation
That is quoted here.
beyond 90 days for a further period of 60 days.
I have within that team. I have already made to the commission also.
That I will record that you have made a prayer to the school authority.
As also to the commission.
Yes, commission page 39.
Yes, ma'am.
That is beyond 90 days.
Beyond 90.
The 8th of April. 20.
That is after the judgment was delivered on 3rd of April. Because petitioner was working at the relevant point of time. Yes. Affidavit of service filed on behalf of the petitioner. I was under the impression that this letter dated 37 is was sent to the commission. That is
No,
not.
the school wanted me to join. The appointment letter was given, joining letter was given.
Affidavit of service filed on behalf of the petitioner. Where is the order? Several orders I have passed. শুধু একটা কারেকশন
क्या मान नहीं होना
The petitioner is still working, being untended candidate.
Salary sheet annexed to pay
Very
copy.
good, very এই শোনো এখানে একটা অ্যাড করো তো প্যারাগ্রাফ 4 একটা অ্যাডিশনাল দিয়ে yes it is also submitted on behalf of the petitioner that within the period of 90 days from the date of issuance of recommendation memo dated 21st November 2024 petitioner approached the school authority where he was recommended in terms of memo dated 21st November 2024. কি মা সেন্টেন্সটা এবার বলো তো where he was recommended by submitting a letter dated 16 January 2025 for extending the time for joining of the petitioner. Stop. It is further contended since approach was made by the petitioner before the school authority within the validity of the recommendation dated 21st November 2024 that needs to be considered by the commission in issuing re-recommendation in favor of the petitioner. এবার বসুন এই শোনো এইখানে ওটা তো অ্যাড করলে এইখানে একটা অ্যাড করবে while taking such decision chairman of the commission shall take into consideration the prayer made by the petitioner Be letter dated 16 January 2025 to the school authority where petitioner was recommended within a period of 90 days from the date of recommendation made on 21st November 2024. আর এইটা হচ্ছে এইখানে এই জায়গাটা ঢুকিয়ে দিতে করে তারপরে ডিসিশন টু বি টেকেন বাই দ্য চেয়ারম্যান অফ the commission. By 4 weeks chairman shall take decision and it is to be communicated to him in terms of proviso to rule 17(3).
Good.
Please call the list.
Item number 25.
At the time of call, accommodation.
This matter is regarding the School Service Commission selection. This matter has traveled to the Honorable Supreme Court. The same is your Lordship's judgment carried in appeal, and then to the Honorable Supreme Court at their instance. One portion still remains, that is the tainted, untainted issue. We did not perform any. The other issues, has been settled by the Honorable Supreme Court now.
What was the order passed by the
Honorable Supreme Court's order is no interference with the Honorable High Court's order, and Honorable High Court's judgment and showing it. Same issue, same fact. Kindly seize the relief sought for. This petition should not be permitted to even. Please see the place. It is already covered.
Tainted, untainted issue was not considered.
No, this is not that.
No appeal was preferred against tainted, untainted observation made by this court.
From the division bench, no. Up to the division bench, the commission did not sense.
Appeal was preferred.
Yes.
By the commission before the division bench, but the appeal was not the order of
the
the court
Lordship judgment was not interfered.
Yes.
In fact, whatever
So you are submitting, nothing remains in this petition.
no, this is not on tainted, untainted. This is on the other part of the judgment.
That has been decided right up to Supreme Court.
Yes.
By the division bench, and that was not interfered by the Supreme Court.
The division bench's
This will
judgment
be
is this. All these matters.
Tentative prayer আছে এখানে F number যা আছে সেটাতে
পূর্ণিমা বল দিয়েছিস?
অরুণিমা পাল পেজ প্যারাগ্রাফ 30
Paragraph 30. Please come to paragraph 8, page 18. The writ petitioners before your Lordship are admittedly untainted participants of 2016 process. That means they were not successful, unsuccessful.
So therefore, the judgment of this court survives.
Yes.
So now what is prayed for in this
Please
petition?
come to paragraph 4 first of the writ petition. যেন বেজটা কোথায় ডিসাইড করেছে পূর্ণিমা এটা রিল্যাক্সেশন অফ এজ যেটা আমি অমিত করেছি
মালতি কোচট ও কিন্তু পার্টিসিপেটই করে
নন পার্টিসিপেট হ্যাঁ whatever that is the age relaxation
বার করছে
তিন করেছিস
না বার করছে
The issue has been decided.
This issue is decided. Now, my lord, apart from the one that I have handed over to my lord, there's another judgment of a coordinate bench of a division bench, which was carried from your lordship's order dated 10th July 2025. Non-participants,
Seeking age relaxation.
age relaxation. This is the my lord ke din. Please see, this is another division bench, same division bench. I'm sorry, same division bench. So perhaps the composition little bit changed. Presiding honorable judge was same. Kindly see the issue.
Yes.
So this being the position actually,
What is prayed for in this?
here, please see page 37 of the writ petition. The iPad গুলো দেখুন। Prayer B, kindly see. Then prayer C.
Yes, yes.
In my humble understanding, nothing remains.
On ground, on whose ground you are praying for time? Let it be adjourned. Issue. Matter is heard. Matter is taken up for consideration when learned advocate representing the petitioner. Now, when on behalf of petitioners, adjournment is sought for on the ground of learned advocate. West Bengal Central School Service Commission is represented by Mr. Bhattacharya, learned counsel, who has made submission based on the order passed on earlier occasions by this court and by the Honorable Division Bench as well as Honorable Supreme Court on similar issue. Next paragraph, hearing of this matter stands adjourned. List the matter under the same heading on. August 2025.
Yes.
Item number 26.
Yes. Area salary.
Purchase. The data set.
When retired. সার্ভিস করেছে স্টেট নয় কি করা যাবে
অনলাইন আছে
পেনশন পেমেন্ট অর্ডার
ডেটগুলো সব ঠিক আছে
when you have served শোনো affidavit service filed on behalf of the petitioner is taken on record করে দাও ও আচ্ছা yes anybody is appearing for the state in this matter item number 26
I am appearing for the state, Ohibushan Chakraborty, through virtually, my lord.
yes very well your appearance is recorded
My lord.
your appearance is...
Much obliged.
আচ্ছা তাহলে এটা শোনো এইখানটা আবার অ্যাপিয়ার করছে না জেনে আবার কেটে দিয়েছি এটা থাকবে একটা জিনিস লাইন অ্যাডভোকেট অনলাইন আর অন ভার্চুয়াল মোডে এখানে করে দেবে এই জায়গাটা একটু অ্যাড করে দেবে হ্যাঁ ঠিক আছে ডিসপোজ অফ
order
My lord.
Item number 27.
Transfer on medical ground, offline transfer application. Child medical ground, child is suffering by.
You are appearing for? Yes.
Child medical ground, where cardiac child is suffering by cardiac disorder.
Child medical ground?
Yes.
Where is the status? Online or offline?
Offline.
Where is the offline application?
Offline application page 18 and application date is page 19, 2nd May 2020.
Just a minute. But the school authority has not issued no objection.
NOC even previously, my lord, petitioner.
You appear for the school authority.
My lord, previously petitioner applied on my lord, in the Utsosri portal on the ground of distance, that is page 23. My lord, once applied, 9th of.
It is on the on child medical ground.
Previously distance.
Previous this application dated 2nd May 2020 child medical ground. Child is suffering from which disorder?
Cardiac.
Cardiac disorder.
Page 17 is the
So
medical
then
document.
it has to be,
Constant
it
family
has,
care.
it has to be through school. So have you served upon the
Yes,
school?
yes.
When you have served?
1st of July, page number 7 or 10. 1st of July,
School situates where?
at Poschim Evening. Respondent number 6.
He has served far back on 5th July.
And my lord, there is an internal communication, page 32, from the my lord regional commission to central commission. Chairperson of West Bengal Regional School Service from Western Region.
Where? Page?
My lord, page 32, that is last page. That it has been remarked that to take
Page 32.
take necessary action. But though it is not my lord, not to proper channels, but since application has received, ma'am, chairperson had chairperson. After prima facie satisfaction, yes, ma'am. Fourteenth.
Commission has received a copy of the application. But the commission, the issue has not reached to the stage of commission.
Right, then not proper way, but it has internal communication that take proper action.
Very well, you serve another notice upon the school authority and I will, what is your instruction?
Lordship, I am appearing for the state. This is my instruction from dear
Tell
Lordship.
me what is your instruction?
Lordship, distance, petitioner is a single teacher and the distance between the school and her residence is not 58 kilometers. This is 18 kilometers. Kindly see the instruction, Lordship. Paragraph 4, Lordship. Column 3.
Anandapur. At Anandapur, I have, and it's a medical distance.
Her residence at Gorbeta.
$18-kilometer distance.
No, my lord, Anand.
Petitioner is permanently stays at Gorbeta under Paschim Medinipur district. She is voter of booth number 130 Gorbeta Umadevi Girls High School and distance of the school from her residence is 18 kilometers.
Lordship, next page.
Is there. Aadhaar card I have annexed, page 12, and
If it is 18 kilometers, then it...
No,
Lordship.
there is no question of it. I am disputing. My lord, Aadhaar card clearly stated Anandapur, which I have clearly mentioned in the cost item. Even page 16, there is a.
But you are voter of booth number 130. It is stated by DI.
Lordship, kindly see the next page I got from the school, Lordship. This is the written, Lordship.
Even medical ground, my lord, is permitted, subject to correction. But I am
No,
not.
if the distance is not there, why on medical ground transfer?
No, my lord, I am not that point, but my awardment is correct. As per my.
If you are staying at a distance less than 25 kilometers, even in medical ground, there is no
I am
necessity.
not on that point, but my awardment is correct. So far as per read petition, Aadhaar card, as per Aadhaar card and distance proof, which I correctly stated, there is no difference.
And we see the paragraph, the second paragraph.
Then my disputed question of let it be filed, decide within the instruction. And the instruction.
बोला second paragraph.
Aadhaar card की, Aadhaar card की जाएगा। Take on exchange of this. Anandapur. My lord, recommendation also shows Anandapur.
No, school is writing. He is also
Here is also
he has also mentioned that
shows
she shows in the paper given us by her lawyer, that she is given to us by her lawyer, that she is discharging her service from Anandapur, Paschim Medinipur. This is not this is not true, as she permanently lives at Gorbeta at her own house, as well as she is the voter of booth number 130 Gorbeta Umadevi Girls High School, serial number 41. Serial number 41 from Gorbeta to our school. The distance is about 18 kilometers.
That is disputed question of fact. 50, my lord, 50.
What disputed?
My lord, my lord, in 58 kilometer in the application form, I stated 58 kilometer. Let the school take a decision.
No, it is to be decided on affidavit.
Lordship, the petitioner is not staying at Anandapur. We have annexed the letter addressed to the DI
I'm
by the
led by Mr. Manote.
in my statement of facts, your lordship, that she is staying at Gorbeta and the distance is 18 kilometer from her residence to the school.
In my support, I have stated, my lord, a voter card, a Aadhaar card, recommendation, even my lord, recommendation. It has been stated on Anandapur. Even my lord, school issued the appointment letter, page 14. School issued the appointment letter, Anandapur.
101 students are there.
My lord, service book, as per rule, my lord, it has been stated, my lord, as per distance to be decided on basis of the service book. My lord, I am requesting the my learned pen produce the service school authority letters service book be produced. That as per rule, service book address is the relevant.
You don't have any residence at Gorbeta?
My lord, that I take instruction. My lord, give me only.
No. Do you have any residence at Gorbeta or not? I will direct the local police authority to investigate and submit a report.
Mr. My lord, give me only one day. Anandapur, my lord, every document it has been Anandapur. I am not suppressed in it.
I am asking you
My lord,
whether petitioner has residence at Anandapur or not.
My lord, give me only one
I will
day.
direct the local police officer in charge of the local police station to submit a report.
My lord, only one day account.
Not today.
Not.
Grateful Lords.
You have placed it.
Record an order. Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner prays for transfer, and in the writ petition, it is disclosed that petitioner is staying at
Anandapur, Paschim Medinipur.
Anandapur, petitioner staying at village and PO and PS, Anandapur, Corona, district Paschim Medinipur. Based on based on disclosure of such residence, petitioner has prayed for direction for transfer of the for her transfer, considering the distance in between the school and residence of the petitioner at Anandapur. So, next paragraph. District Inspector of Schools AC Paschim Medinipur has filed a report dated 17 July 2025, wherein it is stated that petitioner is not residing at Anandapur, but petitioner, by staying at Gorbeta, district Paschim Medinipur, is attending the school, and distance between the school and Gorbeta is 18 kilometers. Stop. It is also disclosed in the report that petitioner is voter of booth number 130, Gorbeta Umadevi Girls High School. Stop. Such report is prepared by the District Inspector of Schools based on communication dated 8 July 2025, issued by the teacher in charge of Uttor Bill Bidhan Chandra Shikha Ayoton within bracket HS close bracket Poshchim Medinipur. Wherein it is stated that petitioner lives at Gorbeta and she is the voter of booth number 130 / Gorbeta Umadevi Girls High School, comma, serial number 41. Stop. Question arises whether petitioner has a residence at Gorbeta or not. Stop. Learned advocate representing the petitioner. Next paragraph. Learned advocate representing the petitioner has prayed for. Having considered this aspect, court is contemplating to give direction upon the officer in charge of local police station to make an investigation and submit a report whether petitioner has a residence at Gorbeta or not. Stop. At this juncture, learned advocate representing the petitioner prays for accommodation to obtain instruction. Stop. List the matter under the same heading on Monday next, comma. 11th August 2025 for further consideration. Stop. Report of the District Inspector of Schools AC Poshchim Medinipur dated 17 July 2025 is taken on.
Item number 28.
My affidavit of service. This matter where my client is paying for higher scale of pay. He was appointed as a teacher in the additional post. Subsequently, her appointment was made permanent. Then she improved her qualification during service with the permission of the school managing committee and prayed for higher scale of pay in terms of the special bench judges.
You are seeking higher scale of pay for acquiring postgraduate qualification. Where is your approval, ma'am?
Page 18 and 19. Page 18 is the first appointment approval in the additional post.
This is dated 16th June. Page 18. Initial date of appointment.
16th September 2009.
September.
At the top, it is 16th September. Memo dated 5th of August.
Date of appointment.
Date of appointment.
Handwritten.
16th of
June.
16 June.
Yes. Now what?
Next page, page 19 is the.
What are the facts? Yes. 16 June appointed. When petitioner obtained qualification?
Then permanent on the page 19. She was made permanent.
Yes.
Then she obtained qualification. The resolution of the managing committee is page 22.
When obtained qualification?
Yes. 2000.
And from which university?
Yes.
Mongolayaton University, UP.
Yes. Yes.
Where you have taken admission? In the main campus in UP or in a study center at Kolkata?
So she has done.
Are you aware of the judgment of Professor Yashpal, 2005?
On weekend,
if you have not taken admission in the main campus of the university, if the university is stationed in another state, then by taking admission in a study center or franchisee, the qualification is not an approved qualification.
But moreover, it is a laboratory based qualification.
where you have stated that you have taken admission at the main campus of the university
I have
in
not
Uttar Pradesh.
That I have not stated. It is
When
in
you have
page-
obtained
page
qualification.
37, Lordship kindly sees the prayer. There it is stated weekend basis, online classes.
The how practical based subject can be course can be completed. It's a physics MSc course.
Yes.
And you are a regular teacher of a school.
But that I have not stated in the petition. In that event, I have to file a supplementary affidavit. She must have done because number is there on lab subject.
When you have completed the course?
Yes. Course I have completed in 2024.
24.
9th of August, I have prayed for higher qualification.
Issue.
But so far my instruction goes, this petition is not.
Reserve your energy.
My lord. That's it.
Petitioner affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner prays for sanction of postgraduate scale of pay on acquiring postgraduate degree in physics from Mongolayaton University, Aligarh, Uttar Pradesh. Stop. It is submitted that petitioner obtained postgraduate qualification in 2024. Therefore, she is entitled to get postgraduate scale of pay. Next paragraph. Question arises whether petitioner took admission. Now, question arises whether qualification, whether postgraduate qualification of the petitioner is a recognized qualification or not, in view of the fact that petitioner obtained such qualification from university which situates in Uttar Pradesh, and it is not disclosed in the writ petition that petitioner took admission in postgraduate course for undergoing hard course of study in the main in main campus of the said university in Uttar Pradesh. On query being posed to the learned advocate representing the petitioner whether she took admission in a study center at Kolkata or not, or in a study center at Kolkata or not, in a study center at Kolkata, satisfactory reply is not. Now, this court does not get satisfactory reply. Stop. Next paragraph. Issue needs to be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. The affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging.
Only one submission. And the records, page 37, I have stated, the letter states that on weekend basis, in terms of the guidelines of.
Not required to record at this stage. Next.
Item number 29.
29, please.
Same thing.
This is the special circumstances, the medical ground.
Transfer.
Medical ground, this one of the date of interview. It's called for interview. On a date of interview, she was admitted in hospital for due to the cesarean case. The baby was.
But that interview was held in 2021.
In terms
subsequently, what steps you have taken?
In terms of the
today court cannot direct to hold a fresh interview. That is the view of this court.
Yes, I understand.
So even if whatever may be the reasons, you could have pursued your remedy contemporaneously in 2021.
That day, the husband of the petitioner appeared before the interview board for praying for time, next date of interview, so that she can appear in the interview. So kindly see page 1110. So that is only the prayer because she first time appear in the personality test.
When appeared? Husband when appeared?
In the date of interview.
What is the date?
Date is the 21st October 2022. In terms of the order passed by the Honorable Deputy Bench, this interview was held. The appeal.
Where you have disclosed the date?
I was called for personality test on
So
21st.
21st October 2000,
Yes, yes.
21st October 2022. After that, what steps you did take
But
for
after
participation
that,
in the
Malad,
interview?
they not accepted because Malati is a in-service teacher. That's why it was not necessary to appear.
You could have filed this case in 2022 in the month
That
of
time
November.
I was in service.
So now, what can be done?
Just praying before your lordship. This is the Malad the facts. Because Malad, this case is Malad, the medical documents is there, Malad. I have.
Yes, I appreciate
Yes.
that on medical
Like,
ground we
lordship,
could not
Malad, kindly,
appear.
this is the
But
fact.
for that today, after 4 years, court will direct to hold face interview.
No.
That is the prayer. That is your prayer.
Actually, whatever, but
Without
this
interview, cannot be enlisted.
thing has come as per the paragraph 47 of
That
the Supreme
court
judgment.
knows.
That's why.
That court knows.
That's
It was done in terms of the court's
Yes,
order.
that is why I'm
But
not cause of action.
why you have not contemporaneously approached?
Because Malati, they have stated in terms of the circular, I am not eligible.
No. Give me an order. Dr. Patro.
I gave it in the morning.
Yes.
One
I
set.
passed an order in his matter.
Item 6.
Item 24, madam.
Item 6.
Item 6.
আজকে সকালে আইটেম 6 হয়েছে সেটা আর কিছু
14,065 বলে
আইটেম 6
It is item number 6.
না
Huh? No, this is not a case of Mukti Vishwas. It no.
Actually, yesterday, that is another. But the recommendation letter, that's another. But today's.
In the morning, I have passed.
This is not possible.
7 8
It is not.
address today morning
I am not
6 7 and 8.
published. But kindly make it not today. I coming with the order of the tomorrow.
তাপস প্রামাণিকটা নেই এখানে
হ্যাঁ আজকে
14049 ও টাইপ করতে নিয়ে চলে গেছি না ওটার মধ্যে আগের দিন অর্ডারটা ছিল তাহলে দিলাম না
I have passed an order relying upon the previous order.
yes
ওর মধ্যে সকালে
that I had handed up in the morning
Yes, yes, I remember.
নাম্বারটা মনে আছে
Not server.
নাম্বার
এই যে সৌম্যদা যেটা দাঁড়িয়ে ছিল সেই অর্ডারটা দিয়েছিলে তো হ্যাঁ
কি নাম ছিল?
কপি রেখে দেবে তো অনেক এরকম ম্যাটার আসছে।
দে হাট কাস্টমার
নাম্বারটা একটু বলুন আমি বার করব
হ্যাঁ সৌম্যদার অর্ডারটা সৌম্যদা দাঁড়িয়ে
সুরেন্দ্রকে ফোন করতে সুরেন্দ্রকে ফোন কর নাম্বারটা শুধু জেনে নে সকালবেলা দেখেছি হ্যাঁ 6 নম্বর আইটেম হ্যাঁ হ্যাঁ
Not today.
Yes.
Item number 30.
কিন্তু একসঙ্গে দেখো। Beyond 30 days, beyond 90 days.
Yes, where is your recommendation? 11.
Page 81, that is page 80. Page 80, second of November.
Beyond 90 days you prayed for extension.
Representation page 20, that is second page.
Days.
You are still working.
Money rate, salary received, page 20.
এটা একটা পাঠিয়ে দিই। এটাও একটা পাঠিয়ে দিই।
Okay.
সেটা আটকাতে একটু হ্যাঁ ঠিক আছে একবার মাছ এটা
Yes, disposed. Yes, next.
My lord has directed the chairman to consider.
4 weeks.
4 weeks.
Application is there, just to be confirmed.
Item number 31.
So, the communication better, but surprisingly, we were after issuing the communication order, no appointment letter has been issued by the school. That is why we are typing. Not be able to issue appointment letter. There is no point of that. I see page 24, sentence commission issue clarification why recommended, why appointment letter not has not been issued by the school.
Where is the initial recommendation?
Initial recommendation, page 21.
Anybody is appearing for the school authority? Who is for the state?
Who issued the suppose notice my lord, page 25, they have admitted that is an inadvertent mistake from their part, vacancy still in the documentation.
Yes, have you received any response to your letter dated 16th April?
My lord,
2025?
kindly make it not today because just yesterday I was discussing with the chairman the overall all these orders which were coming, and he had mentioned one candidate who could not join due to the fault of the school. Possibly this is the same matter. We have already taken the steps. Let me just confirm it.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph, learned advocate representing the petitioner submits, in spite of issuance of recommendation dated 11 November 2024, School Authority of Timlapal Balika Vidya Mandir, Bankura, till date has not issued appointment letter, and no communication was made to the petitioner by the said school authority for verification of documents. As a result whereof, petitioner could not join the recommended post. Stop. Next paragraph. A land advocate representing West Bengal Central School Service Commission has prayed for accommodation to obtain instructions. Stop. List the matter under the same heading on 14th August 2025. So, next. School might have saved the petitioner.
No, chairman told me that in only one case I have extended beyond the period because it was the fault of the school.
So let him take instruction. Let him take.
এটার ক্ষেত্রে আমাকে বলে তো একজনকে করেছে।
Next.
Item number 32.
Client advocate representing the petitioner submits.
I'm for the TPS.
Issue involved in this writ petition relates to primary education. Stop. Next paragraph. Writ petition stands released due to want of determination and be placed before the appropriate bench having determination. Why higher secondary education you have classified it?
Yes, that is the correct thing.
Next paragraph, leave is granted to the learned advocate representing the petitioner to reclassify the writ petition as primary education by amending the presentation form as well as pro forma page of the writ petition. Next,
item number 33.
I am for the statement. Since from transfer application, the NOC has been issued by the school authority offline transfer application. First time applied offline. And there is only one fault because I filed the writ application early. That is the NOC has been issued by the school authority.
you have prayed for issuance of NOC.
Offline transfer application I made on 16th of June 2025. NOC has been issued immediately. And I affirm this application that is from my part, that is I have come the early stage, that is otherwise I hope there is no problem. NOC issued by the school authority
On 16 June. And you have filed it on 30th June.
So apart from 21st. NOC issue, there is no problem. Augmentation of the as stated, there is an augmentation of the strength. School issued the NOC. Everything is clear, my lord. There is no problem.
So what you have prayed for in the writ petition? For prayed for issuance of NOC?
No. Only forward NOC issued already. NOC already.
So how issuance of NOC hinder your petitioner, hinder the petitioner?
So, my lord, NOC, my lord, seems my lord, NOC issued, my lord, there is no possibility they are taking big steps towards suspension of transfer application. So it is lying in the until and unless order for passing necessary order for forwarding is for taking big steps. The school authority is available for making it others.
It is to be forwarded by the school authority.
Yes. Due to suspension of order, they are unable to admit it.
No, but I fail to understand that you are hesitating to place this case since NOC was issued.
But I have come to the lordship in early stage. Early stage, within 7 days, I have attended the petition was
16 June 2025.
But there is no scope for further forward. No scope for further. Only 2-3 matters are here, my lord. Thereafter I rectified earlier. Within 1 month, my lord. Thereafter, my lord, there is no.
So let me dismiss the writ petition being premature, granting you leave to file afresh if situation so arises. Yes, because 16 June 2025, this NOC was issued on 30th June 2025, you are filing it. What is your instruction where the application is lying now?
School of it. I have stated in my application.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. The petitioner made an application for transfer in prescribed pro forma on 16 June 2025, and subsequently school authority where petitioner is presently working issued no objection certificate, quote unquote, on 16 June 2025. So it is submitted by the learned advocate representing the petitioner. Since portal is suspended, school authority has not forwarded the transfer application of the petitioner to the district inspector of schools within the HPC concerned for taking further steps. Next paragraph. State respondents, West Bengal Board of Secondary Education and West Bengal Central School Service Commission are represented by learned advocates. Next. Since school authority has issued no objection certificate, comma, state school authority, no objection certificate, comma, respondent number 6 is directed to forward the transfer application of the petitioner to the district inspector of schools AC concerned by fortnight from the date of communication of this order in offline mode for processing the transfer application of the petitioner. Stop. Court expects if transfer application, court expects after forwarding transfer application by respondent number 6 to the concerned district inspector of schools AC Poschim Bardhaman, steps shall be taken in accordance with law. Next paragraph, writ petition stands disposed of urgent xerox. The comment is for something.
Item number 306 from monthly list of appellate side.
Yes.
I'm for the petition. May I file the application?
I am appealing for this.
And the secondary board.
Yes.
Your Lordship, this is a matter regarding the enhancement of marks in the mathematics paper of the petitioner who appeared for the Madhyamik examination of 2023. Post evaluation, he made several representations. He also made representations for retrieving the answer sheets. He was given so. He made representations before the authority for evaluation, but unfortunately, marks has not been enhanced. This is
why marks is to be enhanced.
Your Lordship, kindly come to page 66. No, Your Lordship, kindly come to page not 66 first. Kindly come to page 33 and 33 first, Your Lordship. Your Lordship may find at the middle portion, question number 13, sub-question 2. This is the question.
Question number 13.
13. Page 33, Your Lordship.
Yes.
The English version is at page 41.
Yes, page 13 you tell me in Bengali.
Your Lordship, the second question. Ekti badi chhat theke, this is the question where
yes.
The answer to this question lies at page 66, Your Lordship.
Yes.
Yes, Your Lordship will kindly see that there is a diagram, a geometrical diagram, and beside that, it has been remarked as Chobi Bhool. The petitioner consulted the authenticated textbook, Your Lordship, and the textbook page is at 75.
See, this court is not an expert in the subject.
Lordship, great.
So therefore, if there is any anomaly in the scrutiny, you can demonstrate. Otherwise, court will not enter into
Lordship,
this issue
they are
based on any reference book.
Your Lordship, I can very
Are you aware of the judgment of Ranvijay Singh of the Supreme Court?
But
Ranvijay Singh. Just look at the judgment.
First of all, the statute rule does not permit reassessment. You are seeking reassessment of the answer script. Re-evaluation does not permit. This examination rules of Madhyamik examination does not permit re-evaluation. Now in paragraph 30.2, it has been observed by the Supreme Court, if a statute, rule or regulation governing an examination does not permit re-evaluation or scrutiny of an answer sheet as distinct from prohibiting it, then the court may permit re-evaluation or scrutiny only if it is demonstrated very clearly without any inferential process of reasoning or by a process of rationalization, and only in a rare and exceptional cases that a material error has been committed. So therefore, what your reference book says, whether that is correct or the endorsement made by the examiner while examining the answer script is correct, that is not to be decided by this court. Court is not the expert in the subject. So, and furthermore, there is no provision relating to re-evaluation or re-examination or reassessment of marks answer script. I can understand if an examinee has given an answer, has written an answer to a particular question that remains unassessed. If that is not, today on perusal of page 666 of the writ petition, it appears it has been endorsed by the examination, Chobi Bhul, ECAE, then note of interrogation. So therefore, it has been assessed and 2 marks was also given. The court should not enter into this arena, which is to be considered by the examiner, that no, the mark should be given not 2, it should be 4. Court will not do this. It is not permissible in the judicial scrutiny. Affidavit of service filed on behalf of the petitioner is taken on record.
Kindly comes to page 76.
Yes, page 76.
The renowned mathematician, Your Worship, and
Maybe. Sorry, what renowned mathematician is saying, that court will not enter into this issue. Court doesn't know what is the consideration of that renowned mathematician. So therefore, court will not enter into that. It is beyond the ambit of judicial scrutiny. Court, this court being a judicial review court, should not enter into that to that extent. It's an exercise to be performed by a subject expert. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner appeared in
citation.
Madhyamik examination 2023. And on publication of result, petitioner is not satisfied with the marks awarded to her.
To him, Your Worship.
আরেকবার সেন্টেন্সটা পড়ো না। আগে একটা উপরে লেখো, petitioner being minor is represented by his father
রাইডারে ছিল
in this writ petition.
পক্ষে চলে
Then তারপরে করো petitioner participate কি বললাম? Petitioner was not satisfied with the marks awarded to him. So, petitioner applied for supply of authenticated copy of answer script of mathematics and and concerned authority of West Bengal Board of Secondary Education, being the examining body, supplied the same. Stop. Next paragraph. Learned advocate representing the petitioner has made an attempt to make out a case that assessment made by the or that evaluation made by the examiner
not today
or evaluation of mathematics answer script made by the examiner is erroneous and answer to certain questions of mathematics paper require answers to certain questions of mathematics paper require awarding of more marks. Specifically, it is submitted answer to question number 13 was not correctly assessed by the examiner. within brackets Roman small 2. The next paragraph. However, examination rules relating to Madhyamik examination rules do not contain provisions which authorizes an examinee to pray for re-evaluation of answer script. Who has passed the examination? Stop. Question arises in absence of relevant rules whether an examinee is authorized to pray for re-evaluation of answer. Stop. Next paragraph. In order to find answer, court is required to rely upon paragraph 30.2 of the judgment of the Honorable Supreme Court reported in 2008 to SCC 357 within bracket Ranvijay Singh and others versus State of Uttar Pradesh and others. Stop. It was succinctly decided in Ranvijay Singh Shupra that if a statute, rule or regulation governing an examination does not permit re-evaluation or scrutiny of an answer sheet, then the court may permit re-evaluation or scrutiny only if it is demonstrated very clearly, without any inferential process of reasoning or by a process of rationalization, and only in rare or exceptional cases that a material error has been committed. Stop. From the case made out in this writ petition, inference cannot be drawn that material error is there in evaluating answer script, which requires reassessment. So, in view, next paragraph, in view of aforesaid, in aforesaid context, no relief can be granted to the petitioner. So, writ petition stands dismissed. নেবে জাজমেন্টটা অনেকদিন অনেকবার
Like today, my lord, another similar order passed by your lordship was under challenge. My lord, on the division the appeal lordship.
by Justice Tandon's division bench, perhaps.
No, today, my lord, by Justice Chatterjee's division bench. Tavabrata Chakraborty's division. Rinita Chatterjee, the matter is today. I just done.
Where is he? Then don't give his name. If he has not come, then don't give his name.
Item number 311.
In this matter, I have appealed for state respondent.
Yes, who is for the petitioner? At the time of call, no one appears for the petitioners and no accommodation is paid for. However, state respondents and West Bengal Central School Service Commission are represented by learned advocates. Writ petition stands dismissed for default. Parties to act on the server cost. Next, application, if any pending, also stands dismissed.
Item number 312.
The transfer application.
Yes.
The petitioner has not made application under the prescribed performance. He has made a representation before the DI matter because of the
petitioner made an application in the prescribed pro forma.
No, my lord, he has not made. Only representation before the DI matter.
That will not do. After Tanushree Karmakar's judgment by the Honorable Division Bench, where is your application?
It's 25.
Justin. Issue. Affidavit of service. Yes, your affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner made an application for transfer on 16 January 2024. So, however, on perusal of said application application for transfer, it is found that Same was not made in prescribed format. Neither petitioner applied on designated portal seeking transfer. Next paragraph. In this regard, reliance is placed on the judgment of the reliance is placed on the order of the Honorable Division Bench dated 14th February 2025, passed on an intra-court appeal being FMA 103 of 2025, within bracket Tanushri Karmakar versus State of West Bengal and others. Stop. It has been observed in paragraph 5 of Tanushri Karmakar Supra that once a thing is required to be done in a particular manner, it should be done in such manner and not otherwise. Stop. The moment the form is prescribed in the rules, shaping an integral part of the statutory provisions, comma, it cannot be whittled down, not to be done away at the behest of the beneficiary of the said rules, nor the other stakeholders of the said rules can dispense with the strict adherence of such statutory norms. So, next paragraph. Since in the in absence of application seeking transfer made in prescribed pro forma, placing reliance on Tanushri Karmakar Supra, such application ought not to be given any credence. Stop. Hence, no relief can be granted to the petitioner, and the writ petition stands dismissed. Next paragraph. However, this order shall not preclude the petitioner to apply for transfer in accordance with law. Dismiss. If situation so arises. Urgent Xerox certificate.
नाम दीजिए बस.
Item number 313.
For this.
Yes.
He retired on 20th December 2020.
Yes.
20th December 2020, madam, he retired. Now, a proper notice was issued, madam, by the Disciplinary authority in the month of May 2019, on 29/5/2019.
Yes.
I replied the same.
Yes.
Now, my lord, thereafter, they say the charge sheet, but I could not know how it is related to a charge sheet. 20, I'm sorry, my lord, 29th May 2019, charge sheet. 29th May 2019. And super notice was 17/12/2018.
What is the present stage of disciplinary proceeding?
My lord, petitioner retired. We have IOPO was appointed by board long back in 2009, but they did not hold any inquiry, did not send any report to us. We have again sent them reminder in May 2024 also to the Commissioner.
Who has been appointed as the inquiry officer?
My lord, one. Pradut Sarkar, Assistant Director of School Education, Office of the Commissioner. Well, we have sent letter to the Commissioner of School Education, to Mr. Pradut Sarkar, and also the Presiding Officer, that is the Assistant Teacher of the school, that is Shonali Sengupta. But my lord, till date we have not received. We have also sent.
So how long this will be kept pending?
Well, they have not hold the inquiry at all.
So therefore, it can be presumed that the proceeding has been abandoned.
Not another writ petition filed by the
No,
petitioner.
that was a previous writ petition, I think, where this suspension
Challenging
was
the
under
suspension
challenge.
Under challenge.
Yes,
No,
ma'am.
no, the order of suspension under challenge, it has not been taken up.
That is taken up now.
Taken up means?
It was not valid, because after retirement, automatically gone.
Why?
After retirement.
Because
with the suspension.
Suspension and the proceeding is under challenge.
Yes, so the
So
suspension.
therefore, unless and until the fate of the disciplinary proceeding is decided, where is the scope of passing an order granting pensionary benefits? Have you received provident fund?
General Provident Fund has been released. General Provident Fund has been released. This is the instruction.
For the state.
Yes, ma'am.
And the inquiry officer is also a part and parcel of the state.
Why?
Just a minute. Yes, just a minute.
পেনশনও পাবে কেন পাবে আমি প্রসিড হ্যাঁ পেনশন দিয়েছে
না
তো পেনশনও পাবে পয়সার পেনশন আর এখন কি হবে আর কি হবে আর কিছু হওয়ার নেই কিছু নেই
But if your writ petition is pending challenging the suspension and proceedings, court ought not to enter into this issue in this writ petition.
If they have no, that is, I have not prayed for any amount of the retired superannuation benefit. That is not.
So what you are praying for in this?
Only the release of the terminal.
Admissible terminal.
Only the release of the. I have not.
So
checked.
if court proceeds on the premise that the proceeding is pending as on date, and that is under challenge in another writ petition being WPA 17945 of 2019. So court will not enter into the nicety of that proceedings, but the petitioner is entitled to get the provisional pension and
Lordship, because there is no allegation of financial
provident fund.
Because there is no allegation of financial defalcation.
The nature of the allegation.
There is no allegation of financial defalcation, Lordship.
What I will do by seeing body.
But pay 70 for my satisfaction.
Because had it been had this proceeding,
Your Lordship kindly have it. Kindly have ample experience.
Page 18.
Page 17. Page 17. 1 second. Point number 1. You are not cooperating with the office since long, so not giving any heed to the some important government projects. Konasri Swami Vivekananda Merit Scholarship, for which students are being deprived from getting benefits of these projects. It is reported Sri Gautam Das, nodal officer, the school had faced immense difficulties to complete the work. In Konasri, not only till today, you have not completed the process of uploading product. Several requests. Regarding Swami Vivekananda scholarship to students are being unnecessarily harassed. Going to our indifferent attitude, they are very much reluctant to sign this. Their application, DI of the school, intervened the matter and they issued so-called notice when you are compelled to allow these students. Regarding admission of class 5, you did not follow the admission norms properly. Several students had prayed for DI of the school, so being denied admission. These students were finally admitted after a long time, almost March 2018, at the intervention of the DI of the schools. It would have serious effect on the career of the student. That some teachers of the institute made allegations against you regarding the late attendance and you have humiliated them with the words in spite of direction of the school, you did not give due attention to their demand. Similarly, Sanghamitra Vishas, assistant teacher in the institute, had faced a serious problem when you withheld her salary and kept dark about the leave application. Since you conducted unbecoming headmaster for you to understand it constant, please notice asking to add why a disciplinary proceedings will not be. Then, my lord, the
issue.
comment
file a report. you file a report, I will direct this writ petition to be tagged with this one. The person who has retired on 20th December 2020 and in the name of initiation of proceedings, she will be denied of terminal benefits including pension for a period of 5 years without bringing the disciplinary proceedings to its logical conclusion.
Lordship.
How long she will wait?
Lordship.
And this is the nature of allegation.
Charge sheet is clear, Lordship, the same.
That I submitted, my lord. There is a defalcation of fund, my lord, in the allegation. That is, I made that submission. So, and when she retired.
The defalcation, monetary transaction.
Until date, no inspection, no inquiry, no report has been furnished.
No furnished.
So the board has to take a stand, being a disciplinary authority, whether you want to proceed with the proceeding or not. If you want to proceed with the proceeding, I will direct by 30 days you conclude the proceedings.
Well, direction is given upon the state also, lordship, to conclude.
No, I will direct the board with the disciplinary authority. Why state? It is your rule. You have to defend it.
The inquiry officer
I will,
is the
yes, who has appointed the inquiry officer?
Disciplinary authority.
So the disciplinary authority has taken. Why disciplinary authority has appointed such a indolent inquiry officer?
As an officer of the state.
That I do not know. You have to either complete it or abandon the proceeding.
Page 22, your Lordship, I believe your Lordship has not gone through this type of charge sheet. Page 22 is the charge sheet, your Lordship can see. Is it a charge sheet at all? Page 22. Only so it is a charge sheet.
আগে যে লোকটা ছিল না ডিসিপ্লিন অথরিটি সেরকম সব অনেক কাজ করে এখন এখন
Who are the witnesses and what are the relevant documents? Based on these charges?
Nothing is there, your Lordship. I find this.
This is the nature of charge sheet, which was issued by the disciplinary authority of the board, not being substantiated by any relevant documents in support of charge sheet.
This is what is there, your Lordship. I have gone through.
Very sorry state of affairs.
2019.
Is what the performance of the disciplinary performance of the disciplinary authority is worse than the school authority. When school authority was the disciplinary authority in terms of Rule 28(8) of the management rules,
Well, at this
old management rules.
well, this particular person is.
So situation is not improved. Situation is getting deteriorated day by day.
No, my lord, this particular person, he is not an employee. He was, he came from the other department. Now he is not with us. Now,
First of
at
all,
present,
there is no
we have
charge
a
of
separate-
financial defalcation.
No.
There is no charge of moral turpitude.
No.
So then,
Well, that is
I could understand that you completed the proceedings. These charges do not attract termination or dismissal.
No.
At best, withdrawal of certain incremental benefits
At best, Lordship.
for a certain period of time. Even then, this order would have been issued against the petitioner. She would have received terminal benefits, including pension.
Lordship. That is the reason I have not objected. I said, my lord, this is there. I have never objected to whatever submission made by Mr. Bari.
So your instruction that the provident fund has been paid,
Yes.
No, just receipt.
not paid,
No,
paid. The provisional pension petitioner is entitled to receive.
Yes.
Yes.
To release provisional pension immediately, I will direct that this the connected writ petition to be tagged with this one and both the writ petitions to be heard on a particular date. In the meantime, board will submit
Take a
a
decision
report
and file it.
disclosing the progress made in the disciplinary process.
Lodge.
Possible for the court valid to tag any day before this violation. So I waited for more than 5 years. I can wait for
Yes.
for 1 month. I don't require provisional pension. Let it be.
No, in the meantime, you take provisional pension. I am fixing a date. Then the final order is to be passed.
If the board proposes not to file a proceed further, then
Matter ends.
Then let us file a
So this charge sheet is nothing.
Lordship, I am not in position to open my mouth.
Issue. Matter is heard in presence of the learned advocates representing the petitioners, state respondents and West Bengal Board of Secondary Education. Petitioner retired on superannuation on 30 December 2020.
Not 2020.
Why 20 December? It must be at the it must be on the last day of month, the 31st December 2020.
Wrongly.
Petitioner retired on superannuation on 31st December 2020. But till date, pension case of the petitioner has not been settled due to pendency of disciplinary proceedings against her. Administrators against her. Stop. Learned advocates representing the parties has drawn attention of this court to the show cause notice dated 17 December 2018. And charge sheet dated 29th May 2019, issued in connection with disciplinary proceedings initiated against the petition. 29th May 2019. Stop. Next paragraph. It is submitted by Ms. Bhattacharjee, learned advocate representing the state, representing the board, that till date, based on charge sheet dated 29th May 2019, inquiry is not completed. Stop. However, it is submitted, progress could not be made in connection with disciplinary proceeding due to non-cooperation on the part of the inquiry officer as well as presenting officer. Stop. Next paragraph, learned advocate representing the state respondents submits provident fund dues have been cleared, provident fund dues have been paid to the petitioner, but no other benefits could be issued, could be released due to subsistence of disciplinary proceeding against the petitioner. Another petition being WPA 17945 of 2019 is pending, wherein petitioner has questioned suspension order and disciplinary proceeding. Stop. Having considered the facts narrated before this court, having considered the facts narrated before this court, having considered the facts narrated, this court is at a loss as to why, even after expiry of 5 years, even after expiry of 6 years, disciplinary authority is unable to complete inquiry. Stop. Unable to complete inquiry, and no inquiry report is furnished. Stop. Secretary West Bengal Board of Secondary Education is directed to file a report in the form of affidavit by 2 weeks, from date, disclosing whether disciplinary authority has abandoned the proceeding or not.
Left with 3 weeks, because if they taken a decision to abandon, then
Very well,
order
by
may
3
be
weeks
passed.
from date, disclosing whether disciplinary authority has abandoned the proceeding or not. Stop. Next paragraph. List the matter under the list this writ petition along with WPA 17945 of 2019 under the heading motion on September 2025 for further consideration. উপরে affidavit সার্ভিসটা করে দেবো।
Item number 314.
For the state board.
Yes.
Matter is pending. My lord, I am the petitioner. There is a irregularities there, my lord, and my senior advocate is going for the Supreme Court matter.
What is the matter about relating to the latest?
Appointments for participating in the Group D counseling. So that has been set aside the entire counseling. So now these are in fact.
Oh.
2016 selection.
Nothing remains.
2016 selection process for non-teaching Group D. Six petitioners are there in the first session.
The third regional level selection test, non-teaching staff 2016 has been set aside.
Yes.
So nothing remains.
Kindly not today.
No, sorry.
My lord, there is
All matters this
irregularities
cannot be
there,
done.
my lord. My lord, their lower merit listed candidate get the
issue. At the time of accommodation is paid for on behalf of the petitioners on the ground of learned advocate. Stop. However, on hearing the learned advocate representing West Bengal Central School Service Commission, it appears that the writ petition has become infructuous. Stop. Next paragraph. In the writ petition, prayer is made by the petitioners to appoint them as Group D staff in a government-aided secondary school in connection with third regional level selection test for recruitment of non-teaching staff 2016. Stop. The entire the selection process, that is third regional level selection test for recruitment of non-teaching staff, 2016, has been set aside by the Honorable Division Bench and has been finally set aside by the Honorable Supreme Court. Vide judgment dated 3rd April 2025 in Boisakhi Chatterjee. 3rd April 2025. Passed in civil appeal arising out of special leave petition within bracket civil number 9586 of 2024 within bracket State of West Bengal versus Boisakhi Bhattacharya within bracket Chatterjee and others. Stop. Next paragraph. In view of since the very selection process is set aside, no relief can be granted to the petitioner as prayed for in this writ petition. Stop. Hence, the writ petition stands dismissed.
So, appearance here. After number. Service setter. Item number 315.
315 also is now infractual.
Same. This is my first SL estimate.
Just for classes 11, 12. 26.
Same.
Yes,
Issue. Affidavit service filed on behalf of the petitioners is taken on record. Next paragraph. Petitioners have prayed for appointment as assistant teacher based on their assistant teacher for classes 11 and 12 based on their performance in first state level selection test 2016 for classes 11 and 12. Stop. However, learned advocate representing the state, representing West Bengal Central School Service Commission submits that first SLST 2016 for classes 9 and 10 has been set aside by the Honorable Supreme Court with a judgment dated 3rd April 2025. Passed.
Lord, 11 and 12.
Passed for 11 and 12. For classes 11 and 12, with a judgment dated 3rd April 2025, passed in civil appeal arising out of special leave petition civil number 9586 of 2024 within bracket State of West Bengal versus Boisakhi Bhattacharya, Chatterjee and others. Stop. Since the selection process has been set aside by the Honorable Supreme Court with a judgment dated 3rd April 2025, no relief can be granted to the petitioners. Writ petition stands dismissed. Next.
Item number 316.
Senior parent.
Yes, what is the matter about?
About transfer matter. Transfer matter.
At the time of call, accommodation is prayed for on behalf of the petitioner. However, at the time of call, accommodation is prayed for on behalf of the petitioner. However, respondents are represented by learned advocates. Stop. Hearing of this matter stands adjourned. Stop. List the matter under the same heading in the monthly combined list of September 2023. Next.
Item number 317.
317, my lord. Mohammed Saroj is appearing on behalf of the petitioner, my lord. He in case in court number 42, my lord. 3 for not to.
At the time, for the petitioner. At the time of call, accommodation is paid for on behalf of the petitioners. However, state respondents and West Bengal Board of Secondary Education are represented by learned advocates. Stop. Hearing of this matter stands adjourned. List the matter under the same heading in the monthly combined list of September 2025. Next.
Item number 318.
Lordship, in this matter, Shantanu Kumar Mitra is appearing for Higher Secondary Council. He is in court number 35. I am praying for short passover.
For the petitioner, what is the matter, Mr. Chatterjee?
Praying for cancellation of the result. There's a benefit under the rule of enabling a student to pass by exchange of marks. The subject in which he or she has failed, that is made the optional subject, and
the optional subject is switched over to third paper. Yes. Fourth paper.
But he doesn't need to pass because this subject in which she has passed, he is required to pass that subject, but to enable her to qualify for nursing. And in the meantime, she has also passed the HS examination from National Institute of Open Schooling. But now she is carrying two high secondary pass certificates. So that is the complication. But the rule provided for that, but there was a time limit. Which is obviously...
Who is for the commission, council?
Lordship, Mr. Shantanu Kumar Mitra is appearing for the council, Lordship. He is engaged in courtroom number 35, Lordship. I am only pleading for short passover.
Not today. It will retain in the list. No, এটাকে রাইডার করে দেখে দেবো।
The rule provides that this
from the date of publication of result.
But this other fraction arose when she passed the other exam and she was told that she cannot be carrying to pass it.
Let Mr. Mitra come.
This is a beneficial legislation at the end.
Item number 319.
Item number 317, my lord.
Rider করে দেবে। Yes, yes.
My lord, Mohammed Sirajan is appearing in view of the petitioner, my lord.
Record an order.
Lordship, 319, my lord, Mr. Shumandi is appearing for the state. He's suffering from dengue, my lord.
Accommodation is paid for on behalf of the petitioner. At the time of call, accommodation is paid for on behalf of the petitioner. And state respondents. Hearing of this matter stands adjourned. List the matter under the same heading in the monthly combined list of September 2025. Next.
Great.
Item number 320.
I am for the state in this matter, my lord. A report was
last petition, my lord. Yes.
No.
Yes, no. Used for the petitioner.
The petitioner.
We are for the board. At the time of call, no one appears for the petitioner and no accommodation is paid for. However, West Bengal Board of Secondary Education and state respondents are represented by learned advocates. You have to file a report.
Yes, my lord.
There was a direction.
There was a.
Why white copy?
Lord, they have not affirmed.
No, it is not. Immediate form is a bold body.
Not in form of affidavit, they have provided with you.
A report filed on behalf of the state respondents is taken on record. So, writ petition stands dismissed for default. Parties to act on the server copy. Next.
Item number 321.
Lordship, Mr. Shumandi is appearing for the state, Lordship.
Who is for the petitioner?
Petitioner lost his interest.
No.
Because of the fact, my lord, page 22, my lord,
petitioner
lost his interest.
Why?
Because class 9 and 10 appointed in first SLST.
Paying for transfer? Transfer?
Yes.
Ish.
Page 22.
Petitioner has paid for transfer from his present post of assistant teacher in a school to another school. However, petitioner was initially appointed on being selected in first state level selection test 2016 for classes 9 and 10. Stop. Next paragraph. Learned advocate representing West Bengal Central School Service Commission submits that the selection process, that is first SLST 2016 for classes 9 and 10, has been set aside by the Honorable Supreme Court vide judgment dated 3rd April 2025. Passed in state of West Bengal versus Boisakhi Bhattacharya Chatterjee. Stop. Next paragraph. In terms of the said judgment dated 3rd April 2025, petitioner has lost job. Therefore, stop. Therefore, question of transfer in case of service of the petitioner does not arise. Therefore, question of transfer of the petitioner in case of service of the petitioner does not arise. Stop. Writ petition stands dismissed. Urgent Xerox certificate copy. Next.
Item number 322.
My lord, I'm for the state, my lord. My lord, area has already been dispersed, my lord.
Who is for the petitioner?
Petitioner is not present.
At the time of call, no one appears for the petitioner and no accommodation is paid for. However, state respondents are represented by learned advocates. Stop. Writ petition stands dismissed for default. Parties to act on the server copy. Next.
Item number 325.
Previous matter. First SLST 2016 classes 11 and 12. 9-10.
Page 17.
Hello. You are for the petitioner. Nothing remains. Page 17. এই শোনো ট্রান্সফার ম্যাটারে একটা এক্ষুনি দিলাম যেটা দেখো তো ওটা ক্লাস 9 10 না 11 12
321
হ্যাঁ হ্যাঁ সেম অর্ডার পিটিশনারের অ্যাপিয়ারেন্সটা দিয়ে দেবে পিটিশনার অ্যাপিয়ার করছে অ্যাফিডেভিট সার্ভিস ফাইলড অন বিহাফ অফ দ্য পিটিশনার ইজ টেকেন ওভার সেম
এটা কি অর্ডার Item number 326.
For the petitioner.
What is the matter about?
Regarding transfer, regarding age correction.
Waiting for time.
Went to hospital for treatment of operation of her wife.
At the time of issue. At the time of call, accommodation is paid for on behalf of the petitioner. At the time of call, accommodation is paid for on behalf of the petitioner on the personal ground of the learned advocate. However, board is represented. However, West Bengal Board of Secondary Education is represented by learned advocate. Stop. Hearing of this matter stands adjourned. List the matter under the same heading in the monthly combined list of September 2025. Next.
Item number 327.
Your Lordship, Advocate Ondipon Pal is appearing in this matter. He has not come to.
Don't pray for time.
Therefore, interest
Matters
for
are running
medical
for quite long time. Don't pray for time.
Therefore, interest
To the matter. Yes.
Therefore, interest for medical leave, my
Interest
for medical leave, special medical leave.
medical leave.
Kindly see my page
We know interest on gratuity, interest on medical leave.
That is my lord. They are my
What does it mean?
page 0. Page 10.
Just, I'm not today child and not say
You are not there in this matter.
No, Your Lordship, I was just asked by his clerk to take time. He has not come to court today.
Very well, let one chance be given on the next date. No further accommodation. At the time of call, accommodation is prayed for on behalf of the petitioner. However, state respondents are represented by learned advocate. Next paragraph. Acceding to the prayer made on behalf of the petitioner, hearing of this matter stands adjourned. List the matter under the same heading in the monthly combined list of September 2025.
Okay.
Next.
Item number 328.
Petitioner had participated in the first SLST for the upper primary level, which has not been set aside by Supreme Court matter.
What you are praying for? In connection with first SLST upper primary.
Upper primary, what had happened, my lord, during the filling up of the forms, there was an inadvertent mistake. If my lord kindly takes up page 31 of my petition.
Have you participated in the interview? No.
My lord, the only thing is that I am a para teacher.
Up to which stage you have participated?
But I've participated, but I could not upload documents in support of the fact that I'm a para teacher, because there was an error in filling up of my application form. First day I said that I'm a para teacher. I corrected it thereafter. There was other errors. While correcting, inadvertently the word para teacher was omitted. That is the reason why I could not upload documents in support of the fact that I'm a para teacher. That is,
so you could have raised a grievance before the grievance redressal committee. Have you done so?
After there was a notification on 21st January.
Now today, what you are praying for? When you could not upload your testimonials as para teacher?
As para
in 2021?
In 2024, my lord. The notification, my lord.
This was when this was held. Uploading of documents in connection with para teacher.
Para teacher portion, it got separated. That 10%.
So when this uploading of documents as para teacher was conducted.
This candidate, since the candidate, while editing the form, has erased the para teacher status, then the petitioner, I do not think the petitioner was treated as a para teacher. So he will be treated amongst the 90%.
90%.
So if that be so, then the interviews were held in 2021.
For 90%.
Yes, for 90%.
But petitioner is claiming the status of para. Petitioner is claiming status of para teacher.
Yes, that has not yet been done. Interview for para teacher.
That matters are being considered by this court.
January 22, 2020.
Next Thursday week, next Thursday it is being fixed. Yes, I know. On 14th it is fixed. So whether this matter can be tagged with other matters?
Kindly do not tag it. Actually take instruction.
Very well.
That what was the fate after it.
Now petitioner is claiming to be treated as para teacher. Now since the interview is not held, so therefore still time is there so far petitioner is concerned, and whether petitioner can be considered as para teacher, that issue can be decided by this. That issue needs to be decided by this court. So you obtain instruction and come back. issue. Petitioner participated in first SLST 2016 within bracket upper primary. Shorte করবে না first state level selection test. প্রথম বলতে না, petitioner participated in first state level selection test within bracket 2016. এরপরে যখন বলবো SLST 2016 না within 16 right upper primary right upper primary. But while uploading documents, petitioner did not mention while describing
But in first
herself as
Not uploading documents.
online. Oh, in the application, she has not described herself as parateacher.
Initially,
The candidates were given an option to correct any mistake. That I think the petitioner.
so while correcting it,
Delete it. The annexes are there.
Page 30, 31.
31 and 30.
33 the word parateacher is not there, 31 it is there.
না বাকিটা কেটে দাও। By submitting application
পয়সা দিয়ে
initially describing herself as parateacher, but subsequently while opportunity was granted to the candidates to make necessary corrections, petitioner described herself as herself not as parateacher,
And if
by
the word
by
wrongly
by
is used.
incorporating necessary corrections. Stop. However, learned advocate, next paragraph. However, learned advocate representing the petitioner submits that petitioner needs to be treated as parateacher and is required and benefit of 10% reservation which was provided to the parateachers in connection with aforesaid selection process needs to be extended to the petitioner. Stop. Next paragraph. Learned advocate representing West Bengal Central School Service Commission has prayed for accommodation to obtain instruction. Stop.
Any day after
Hearing of this matter stands adjourned. List the matter under the same heading in the monthly combined list of September 2025 in order to enable the learned advocate for the commission to obtain instructions.
But if it can be on a supplementary
No.
list any day,
Sorry.
after 14 since the other matter is on 14.
No.
Item number 329.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. However, West Bengal Central School Service Commission, you are for the commission?
My lord.
However, West Bengal Central School Service Commission is represented by learned advocate. Writ petition stands dismissed for default. Parties to act on the server copy. Next.
Item number 330.
My lord, in this matter, I am appearing on behalf of the petitioner, my lord. What happened, my lord, in a selection process, in the post of Group D, petitioner participate.
Which selection process?
Selection process at that time, my lord, recruitment rule 2005, my lord. At a school, Group D post, my lord.
2005 selection process, Group D.
Group D, my lord.
By the school authorities prior to 2009.
2009.
Yes.
My lord, thereafter, my lord, petitioner stood first in the panel. One of the participants who stood second in the panel challenged the same. File a writ petition. The writ petition disposed by directing the district inspector of school to consider the same. After considering the same and upon hearing both the petitioner and who stood in the second in the panel, petitioner appointed in the post. Thereafter, my lord, that person who stood second in the panel filed a contempt petition. That is why, my lord, My lord, kindly come.
So
to-
you stood first in the panel.
My lord, my
Then
lord,
you were
kind-
appointed.
My lord, kindly come to page 24, my lord. My lord, appointment for the post of Group T on the date of 11/9/2006, my lord. But my lord, there is a conditional appointment. The approval of the appointment will be avoided by the result of the CPN such and such, my lord.
Yes.
Yes. My lord, now I am completing my 18 years of service.
Yes.
For that conditional appointment, that
You are
is why
not
my
getting that benefit.
benefit, my lord. Now, my lord, kindly come
Now,
to
what is the fate of this contempt proceeding?
my lord, kindly come to page 21, my lord. My lord, contempt discussed on 23rd February 2007, my lord.
Page 21.
Page 21, my lord. As per my lord, status report from the server of the High Court of Calcutta, my lord. So, my lord, I pray for praise approval.
38914. 389. Dismissed. So why the DI is not issuing modified approval memo?
Perhaps DI was under the impression that the contempt is still pending. Perhaps, my lord.
Why you have not annexed the order passed in the contempt?
My lord, I have not getting the certificate, copy of the
Advocate copy.
not getting that, my lord.
Because in some cases, if it is dismissed for default, then also it is written as.
Even if dismissed for default,
yes,
court has to proceed on the basis if it
Yes.
is not, if the
No.
petition is not restored within
yes,
reasonable time.
Certainly, certainly.
My lord, dismissal 2007.
Affidavit service.
Yes, my lord.
Affidavit service filed on behalf of the petitioner is taken on record. Stop. Petitioner was selected in a recruitment process initiated by the school authority at the material point of time in terms of relevant recruitment rules for the post of Group D in Mohishadol Goeshwari Girls High School within bracket HS close bracket Purbo Medinipur. Stop. Petitioner, you are the first impanel candidate.
Yes, ma'am.
Petitioner being the first impanel candidate was appointed on 11 September 2006 by the by the aforesaid school authority by the aforesaid school authority and approval was granted in favor of the petitioner by the concerned district inspector of schools AC Purbo Medinipur being respondent number 4 with a memo dated 5th February 2007. Stop. However, approval granted with a memo dated 5th February 2007 was conditional one in view of pendency of contempt proceeding being CPN 1205 of 2006 arising out of WP number 24887 or arising out of writ petition being WPA 24887 of 2005. Two four eight eight seven was disposed of.
Yes, my
Yes, my lord.
Stop. Learned advocate representing the petitioner has drawn attention of this court to a document at page 21 of the writ petition. Wherein status of the aforesaid contempt proceeding is available. Stop. It appears from the said document at page 21 that contempt proceeding being CPN 120 being CPN 1205 of 2006 was dismissed by a coordinate bench. Next paragraph. It is contended on behalf of the petitioner, since conditional approval was granted with a memo dated 5th February 2007 due to pendency of said contempt proceeding, petitioner is not getting 18 years service benefit. Next paragraph. State respondents are represented by learned advocates. Next paragraph. Having heard the learned advocates representing the parties and on perusal of record, nothing is found from where it can be concluded that CPN 1205 of 1205 of 2006 is still pending. Stop. On the contrary, document at page 21 shows that it was dismissed on 23rd February 2007. Stop. In view of aforesaid situation, respondent number 4 is directed to issue fresh approval memo in favor of the petitioner. Upon treating the petitioner's approved service as Group D staff of the aforesaid school with effect from 11th September 2006, within a period of 4 weeks from the date of communication of this order. Stop. After issuance of fresh approval memo, steps shall be taken in accordance with law for extending 18 years service benefit to the petitioner if petitioner is found to be eligible otherwise. Stop. Next paragraph. Writ petition stands disposed of. Urgent draft certificate copy. Next.
Item number 331.
For the repetition, I'll be candid, there is no scope for any interim order in this. Now, this has to be disposed of on affidavits.
Other educational service means?
Is for reclaiming certain monies, my lord, which I am entitled to under a scheme, my lord. I am a person, my lord, who has been in service under the Border Security Force. My lord is aware, my lord, that the servicemen of the Border Security Force are covered under various schemes, my lord. Now, one of such scheme is that
No, how Sainik School Society and the Sainik School is involved?
Now that this money,
If you are
wait, please wait. Yes, ma'am.
serving under border security force, then this before this bench writ petition should not have been. This bench has no determination.
No, the money has been declined. I am entitled to the money from the border security force because money is payable by the border security force. They would
For
be
what?
There's a subsidy which I am entitled to get. If once my ward is in some hostel, I am entitled to 2 subsidies.
Who are you?
I am an ex-serviceman of the border security force. Now there is a scheme of the border security force that if your ward is in some boarding school, you would be entitled to 2 benefits. One is a children education allowance of 2,000 rupees and a hostel subsidy.
How this issue can be termed as an education matter? The service matter.
Service.
It should come under the heading Group 6, not Group 2.
That I should go before my lord.
Suppose you are not getting house rent.
Yes, yes. That is
Being a member of a discipline force, will you approach this court?
that I should go before. Please, I will go before the court.
My lord, I beg to appear virtually, my lord, for respondent number 1, Union of India, lordship.
Yes, but this matter should be termed as
Yes, my lord. Very well, my lord. This is my lord, because this arises out of the service, my lord.
Of the son of or ward of the petitioner is claiming certain benefits from his employer.
Yes, absolutely.
So that is precisely your case. Yes.
Then I should go before.
My lord, although our submission he is not entitled to, but this is not before.
That he will make before the appropriate bench.
My lord.
Learned advocate representing the parties submits. The issue involved in this writ petition relates to
service.
The issue involved in this writ petition should come under the under group 6 of classification list of different types of writ proceedings. Leave is granted to the learned advocate for the petitioner to amend the presentation form and pro forma page of the writ petition and reclassify the writ petition as group 6 matter. Stop. The writ petition stands released due to want of determination and be placed before the bench having determination.
I am really
grateful, my lord. With my lord's leave.
Yes, take back immediate service. Right.
Okay, amendment. His presence we recorded.
Yes.
Item number 332.
My writ petition. So I served all the respondents. Yes, my lord, I am seeking a direction upon the respondent authority for refund the overdall amount as well as.
Who is appearing for the state?
My lord, I served the.
When you have served?
This
writ petition was filed 21st February 2024. It must have been served. Notice must have been served, intimating that matter to be moved before the different bench. Issue. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Respondents are not represented today. Stop. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the respondents or the learned advocates representing the respondents, enclosing copy of this order by fortnight from date and file affidavit of service on the next date. List the matter under the same heading in the monthly combined list of September 2025. Next.
Item number 333.
I have my affidavit of service. But I am for the school authority.
Only
Let
by
me
there
please
is
Chaturvedi.
for any interim order, I am challenging the dismissal
Let me find out whether there is any scope for admitting the writ petition or not.
But the maintainability of the, but I am raising the question of maintenance of the petition.
Maintainability.
This is a de-getting school. I am
Unaided school, that is DA does not make it a aided school, your lordship.
I have held in Baliban Sikha Sadhan.
Yes.
After, my lord, an order of the division bench of justice, and then after going through that order, your lordship, we have changed your mind in another matter.
No, this judgment is not applicable to the case of the writ petitioner.
The DA getting.
I passed an order in Baliban Sikha Sadhan case.
Yes.
Then holding the writ petition is maintainable.
Yes.
I'm not.
By relying upon a particular paragraph of St. Mary's judgment delivered by the Honorable Supreme Court. Now the appeal was preferred before the division bench presided by Justice Tandon. Perhaps Justice Tandon released the matter on person.
I am not on maintainability. That writ petition is maintainable as per my understanding. I am not on that point, but it's an unaided school. So, my lord, any disciplinary proceeding, whatever is to be done by the school authority, not by the board. That is only my side.
And approval of the board is required.
Not required. Well, this point has been decided, your lordship, by a coordinate bench, two coordinate bench.
And the maintainability issue has been raised by the school. I appeal for the school.
That I am not on that point, but my lord, on this that issue, my lord, there are decision of.
Now, what is the present stage of the proceeding?
Termination letter has been issued.
When termination letter was issued?
2023, the exact date.
That is termination letter is at page 166.
September, 24th September.
24th September 2023.
You submitted that in 2018 rules, DA-getting schools are kept outside the purview.
May I clarify, my lord?
Unaided schools are kept outside the purview.
My lord,
That are not aided schools. That has been defined in two coordinate benches, Justice Lordship.
Marwari Balika Vidyalaya, it has been decided that DA-getting school is an aided school, and that was taken care of by the Supreme Court in the judgment of St. Mary's.
So far as the DA-getting school is concerned, my lord.
That is on point of maintainability, Lordship. DA-getting as an aided school. On point of maintainability. That I am not.
It is fully self-finance school question is different.
This is still self.
When
DA is not released to the entire staff.
you know the salary component of the teachers who are approved by the DI, you will find that DA part is higher than basic part.
Yes.
Because these schools do not pay salary in terms of relevant ROPA rules. Then this is a form of aid school is taking.
Yes.
Why it will be called identified as unaided school?
That it has been identified in the rule itself.
You find out the judgment in Marwari Balika Vidyalaya.
Yes.
Lordship, and there
It
are
has been decided.
These judgments have been dealt in the two.
And that has been distinguished in the case of while deciding the issue in St. Mary's case.
Well, this has also been.
St. Mary's is in favor of the
Come back on the next week.
On Monday, my lord. On Monday.
That I do not. Has it been stayed by the Honorable Division Bench?
No, not interfered.
Oh, not interfered. It was moved before the Division Bench. No, first Justice Tandon released the matter you submitted.
336.
336.
Your lordship's order was not touched.
That is on the point of maintainability, Lordship.
Yes, I have decided that it is maintainable, and then passed an interim protection to the petitioner in Priya Chatterjee.
But here, this is the point of maintainability. I am saying, my lord, this is an unaided school. So, my lord,
same issue was considered in a different manner in Priya Chatterjee. Give a copy of the order to Mr. Miss Madrasa.